Just a note about procedure for today. We're going to start by hearing from GFL, the appellant. We'll then hear from our administration. We'll then hear from any members of the public. And finally, we'll hear from GFL. Are there any procedural or kind of preliminary issues that we should be discussing? If you want to just push the button on your microphone, it just aids with the recording. Our meetings are recorded and may be posted on Wheatland County website or on social media.
I do have a preliminary matter with respect to which I've discussed the matter with my with both the counsel for the administration and counsel for the council itself, and we actually are going to ask that the hearing be adjourned for reasons which I'll explain. And before I start, I'd like to mention I should introduce myself. I'm Stephen Robertson, I'm counsel for GFL. I'm assisted today by Chatal Jas, who is one of our students, and I also wanted to mention that Matthew McCara, who is the area vice president for solid waste Western Canada for GFL, is present in the gallery today.
Thank you.
The need for an adjournment comes as a result of the fact that we do not yet have the written reasons of Madam Justice Ho of August 9th. We had requested those immediately, but the process with the courthouse is that when a judge delivers a decision orally, once it's transcribed, anyone can order a transcript, of course, of any proceeding, but before the judges release their transcripts, they review it. And so, and Justice Ho almost immediately went on vacation went back on vacation really, after hearing the application. And so she had not for some time reviewed the application, reviewed the transcript and approved it. I'm told that she has done that, but that we still don't have a transcript. And the other matter that's relevant to that is that we have intend to bring an application for advice and directions before Justice Ho with respect to the effect of the orders, her order and the 4 orders that were issued by the administration. And the reason for that is that in the application that she heard, Justice Ho considered 2 main things. The first was an application by GFL for a stay of proceedings and stay of enforcement of the stop orders and the remedial order that were issued by the administration. And there was also an application by Wheatland County for inspection and seizure of documents and samples from the site. Now, Justice Ho did not consider the merits of GFL's application for judicial review. That application was not before her. It was a stay of proceedings pending that application. So she could not have refused to have granted that application. There's a press release, I know, that's been issued by Wheatland County, which says that Justice Ho dismissed the judicial review application, but she did not. She could not. It wasn't amongst the matters before her. And the press release also states, I'm just briefly read from one paragraph of it. It says, in connection with this matter, Wheatland County also applied to the court for injunctive relief in an effort to enter onto the GFL facility site to better understand the environmental conditions on site and to assess the safe removal of the nuisance conditions that are present there, which has impacted our residents. As detailed in the court decision, Wheatland County's request for relief was denied, which indicates we are unable to enter the premises for inspection. Wheatland County is reviewing the court's decision and assessing options going forward. Now, I don't know what the review and assessment of options going forward is, but I don't know if that includes a possible appeal of the order of Justice Ho on that point. But that matters with respect to the rest of the orders because GFL is attempting to comply with the orders. They want to comply with the orders, but some confusion has been created between the July 3rd and July 5th orders and now the order of Justice Ho. If you've reviewed the orders, you'll know that the July 3rd order instructs GFL to stop accepting new feedstocks and to remove or process and remove the legacy pile within 90 days. The July 5th order instructs GFL not to do anything to disturb any soils or to remove any soils or liquids from the site until the site can be inspected and an independent report prepared, independent expert rather, prepare a report on the site and the issues with respect to removal. And a number of other things were asked for in the order, which we will discuss when it comes time to talk to the appeal, to address the appeal. But I note that, as I said, Justice Ho dismissed the application to access the site, to perform an inspection, to take samples, and require the production of records. And in doing so, she found that the county, if the county was going to do an inspection, it should have done that before issuing the orders. And she was not going to permit it now. A number of Justice Ho's comments would appear to be critical of the administration's approach in this matter. So, for example, she noted Mr. Henderson had chosen to conduct his inspection on June 27, 2019, from the road. Now, the dismissal of the county's application means that there will be no inspection. So the events that are contemplated in the July 5th order, which are to determine when the July 5th orders stop having effect, or parts of them, are in fact will not happen. They may never happen. So what does that mean for the remedial order? Well, it creates some confusion. For example, when does the time start to run to process the legacy pile if there's not going to be an inspection? The July 5th order is impossible it's impossible of performance. It can't be, or at least it's missing a significant part because the contemplated inspection simply won't occur. Now, GFL provided a letter to Council for the Administration on August 15th of 2019, which we've provided to Council, and should be in the materials that you've received from GFL. And in that letter, GFL, in an effort at transparency, identified the problem I've just described and set out what it thought it should do going forward with respect to each of the conflicting points in the orders. The administration's lawyers responded with a letter that did not acknowledge the difficulty, despite what it said in its August 9 press release about the order that had been granted and that it was still considering its options. It didn't provide an alternative position or a substantive response, despite the fact that it's clearly impossible, in my submission, to comply with all of the orders as they currently stand, as they're currently worded. And my response on August 16th highlights some of those concerns, and I've had no response to that letter. So it's for those reasons that GFL is bringing this an application for advice and directions before Madam Justice Ho. If we are in a position where GFL, reviewing the orders, sees clearly that there are things that are obviously inconsistent, that is, they are to remove the legacy pile within 90 days. They are not to disturb the site. They're not to do anything, and they're not to disturb the site or remove soils until an inspection happens that Justice Ho has said isn't going to happen. Then there must be some other path. We've been told by the response from the administration, however, has been only that They will use our letter against us and consider it to be admissions. Frankly, I had intended it to be an attempt at transparency. This is what we're doing. And the response was not constructive. So until we have some clarity provided by Justice Ho with respect to those issues, as well as the issues with respect to the judicial review application, which is still existing, still on the court file, and it will still proceed eventually, as soon as possible, we hope. We need her advice and directions as to what we should do next, as we apparently are unable to agree or even really discuss it. So in my submission, it would be unreasonable for council to proceed to review the orders and decide whether they should be affirmed or modified or canceled when the orders appear to be conflicting and there's doubt as to the current status of the orders. And the means to clarify the current status of the orders is an application for advice and directions that can't be brought until Justice Ho returns from her vacation. We've been told she's back in the first week of September, and at that time, I've already contacted her office, and based on past experience, I would expect her to provide us with a date that we can appear to clarify the order. And again, at this point, we still don't even have a transcript of the order, so it's very difficult to have a discussion based on what was ordered, based on recollections that apparently can be so different that the administration reported that Justice Ho had dismissed the judicial review application, for example, when that did not occur. Those are my submissions.
Council's consideration of the request for an adjournment.
I wondered if I could make a couple comments in respect of that on behalf of administration. First of all, this process is independent of the applications to Justice Ho. You have a very broad ambit of discretion in terms of the process that you follow. I would also suggest that the counsel for GFL is referring to an application that he has not brought at some time in the future that Justice Ho may consider. I would further note that the interpretation of the orders and how they work is precisely one of the things that you're being asked to do. And further, to the extent that there are concerns that we want clarification from Justice Ho on, in our respectful submission, there is no there's no impediment to proceeding and prior to issuing any kind of decision, adjourning for allow for questions or for allow for that process to go ahead. From our perspective, we're here, we're ready, and it's certainly open to council to proceed as it sees fit. Thank you.
Thank you. Any questions from council? Comments? Any questions for either of the councils? I'm going to move us in camera for a brief in-camera legal consultation with council's legal counsel. All in favor? Opposed? Motion is carried. I'll move that council come out of camera, back into public council. All in favor? Motion is carried. Council has reviewed the request to adjourn and has determined that Due to the absence of any judicial direction to not proceed with today's review, we will be continuing. We've all assembled, we're all here. We've been provided fulsome information to review, so we would like to continue with the review today.
I'll begin with some brief introductory remarks. I believe that Council has had the opportunity to review all the submissions of the parties, and so you're familiar with the general facts that underlie the appeal. But there's a few things I'd like to go through and highlight. You'll know that GFL acquired the facility as of June 1st of 2017, and at that time it acquired the facility, there were a number of issues that it began to address through both Alberta Environment and with the county. A number of questions were raised by the Neighbours Against Pollution, or NAP, and the county consulted with Alberta Environment and NAP, and county administration reported to the county. Now, if I can refer you to tab D of the appeal binder, that's the date July 17th, should be tab D. First document is a request for decision. July 10, 2017. D. Delta.
Is it possible to have it pulled up on the screen? Can you give us the page number?
The pages aren't numbered. It's the first. I'm starting at the first page of under tab D.
Thank you.
Does everyone have it?
You bet.
Okay. So this is a request for decision that's submitted to council, and it'll be on page 40. You'll see that there is a document titled Wheatland Compost Site Owned by GFL, Green for Life, report prepared July 9, 2017. And this, I understand, is a report that was prepared for council that essentially addresses a number of questions that were raised by NAP and were answered by Alberta Environment and Parks, and then provided in this document to council. And you can see that at the first point there's a reference to concern about litter being deposited on adjacent sites, and a note that each time the peace officers visited the site, the surrounding area was clean. There's a comment on a report But on page water report, which the administration indicates they don't have the expertise to comment upon. And then there's a reference to correspondence received from Mr. Kameni and Neighbors Against Pollution, which were attached to the report. And then it goes on in paragraph 4 to talk about the fact that administration had been in contact with Alberta Environment and Parks in connection with obtaining information with regards to some of the comments and requests submitted in the correspondence noted above. And the first question was, can AEP measure the piles to confirm quantity? And the answer is, no, I don't have the means to survey the piles. As well, I have no reason to doubt the quantities reported by GFL/Biochem. And then there's a reference to the drywall, sulfur, and tailings on the site at that time. Alberta Environment and Parks was asked if they could sample the piles to verify contents, and the answer was there are 3 piles: drywall, sulfur, and tailing. Drywall and sulfur are not worth testing. We know what they are. The tailing pile is standard composting material, organics that do not fully decompose on the first trip through the composting process and form matter such as plastics. The next question was about groundwater, and the question was, can AEP demand groundwater? And the answer was it was already done. So groundwater testing was already in place. There's a question asked about surface water contamination, and the answer there explains the purpose of a leachate pond and that there is one in place here, and that essentially testing is only required if there are releases off-site, which have to be reported. Question asked about the sulfur, which is answered, and indicated that there's no more than 100 tons permitted without approval. A question about treated compost, and a question about the clay base liner, which also receives what should be a comforting response from Alberta Environment. So this is all information that the administration of the county would have had as far back as July of 2017. Now, that information and more was confirmed on July 16th of 2019 by James Jorgensen, who's, as I'm sure you know, is a employee of Alberta Environment Parks, who is tasked with reviewing, amongst other things, GFL. And I've provided you with a copy of an email exchange amongst Mr. Jorgensen, Craig Naus, Matthew Boscariol, Brian Henderson, and Jamie Peters. It's July 16, 2019. And this email exchange starts on page 3 of the document, in substance on page 2. There's an indication on July 2 that there's a number of complaints about the facility that's referenced, which appears to be the GFL facility near Strathmore. And the complaints received include noxious odors, garbage blowing off-site, contaminated water flowing off-site, including gypsum and sulfur from large piles of drywall and sulfur and noise. Now, of course, on July 2nd of 2019, as you will know from reviewing the materials, there certainly were no piles of drywall or sulfur on the site. And it would appear from the other documents that garbage blowing off-site was no longer an issue at that point either. But the point of this is to look at the response, because initially there's a response that confuses the sites. It's talking about a different site near Airdrie, not one of GFL sites. It actually says in the document,
We have to ensure that we maintain respect in council chambers, please.
you'll see that in Mr. Knaus's email, he refers to information from TNC.
Can
And
you reference the page, please?
page 2, it is in after the greeting, it is in the third paragraph. Information and Parks has conducted on-site inspection, received information from TNC and identifying how they will be addressing the findings of the inspection. Mr. Jorgensen leaves no doubt in his reply, which is on the first page, in which he says, I would like to jump in and make a correction. Craig is referring to a different compost operation in the Airdrie area. The GFL facility in Strathmore has received, I think should be received, a lot of attention from AEP from about 2016 to early 2018 and has been, he says quiet, but I think it's quiet, ever since. Numerous briefing notes were sent up over that period. The main concerns with this site were odor, drywall, sulfur, and fugitive litter. The sulfur and drywall were used to blend a CFIA registered soil amendment product GFL sells. In early 2018, all of the drywall and sulfur were removed from the site. The product is no longer blended at this site. A groundwater monitoring program has been in place for a couple of years now. The monitoring results have not raised any concerns about contamination. GFL now uses large mobile fencing to surround the area where work/screening is occurring to capture loose plastic and paper. The main source of odor is from an old pile of compost known as the legacy pile that GFL inherited when they took over the operation of the site. Initial GFL was digging into the pile aggressively, which released entrained gases and was a source of the odor. They have since changed how they handle and process the legacy pile, which has reduced the odors released. I have been on site many times working with staff to ensure the site is in compliance with the Code of Practice for Compost Facilities. The most recent site visit was on July 9, 2019. The site is in much better shape than it was back in 2016 and continue to improve. To clarify, there is not an ongoing investigation at this site. If further information is required, my number is, and he sets out his phone number. So this is the view of the individual at Alberta Environment and Parks as of July 16, 2019, based on his familiarity with the site and his review of the site, his visit to the site as recently as July 9 of 2019. And that document is copied to Matthew Boscariol and Brian Henderson. Now, I'm sure Council will remember that after GFL took over the site, there were numerous discussions, and GFL was asked to do a number of things. There was an action plan that was agreed to, and there were a number of things that were put forward through Council's administration, many of which originated with NAP. And so, for example, it was asked that GFL build a fence around the facility, repair the berm. It was asked to reduce the height of the gypsum pile and remove the sulfur. It actually undertook to remove all of the gypsum. They had thought it had all been removed and then found some under a little bit under a part of a berm in July of this year, which was immediately removed from the site. So, and in early 2019, they were asked to agree to an engagement strategy. Now, GFL did those things. some of them happened later than had been anticipated, but they did them, and they were working cooperatively with the county, and there was discussion back and forth about what they could do and what they couldn't do, but there was a dialogue, and that's indicated in the letters. There are letters between council on the attached to our argument. But then in February of 2019, it appears that the county retained Gowlings. The purposes for that are set out in the press releases or in the media releases following, and in the newspaper articles that were reported at the time about following up from a September meeting in which a recommendation was made to hire an aggressive environmental lawyer. Apparently, a consultant was hired in February. GFL does not appear to have been aware of that. Now, however, because what GFL was doing at that time was discussing the engagement plan. In March, there was a site visit that was arranged. And in May, there was an exchange of correspondence between Brian Henderson and Don Francis, and that's attached to the affidavit of Brad Walls, which is amongst the materials I provided, or that I forwarded, would be the first document of the new materials. And there was that exchange. You may recall seeing at some point, but that was a request was forwarded by Mr. Henderson, essentially asking, we understood directed by Wheatland Council, that Wheatland Council directed Wheatland administration to obtain an update on the facility and address some inquiries from NAP. And Mr. Henderson requested GFL work with Wheatland on the following requests, and one was to facilitate a site visit for a group of 3 people, but including an external expert, the Daryl McCartney, who prepared an independent assessment of the facility around June of 2018. They asked if NAP could fly a drone over the site every 6 months so the status report could be provided, and also NAP had expressed the view that no sulfur or amendments be allowed at the facility, only organics. And Mr. Francis responded to that. With respect to site tours, he was happy to accommodate that, but would have limited them to key stakeholders, not the external expert, and that they would have to be supervised. He declined to agree to the drone flyovers because of a concern about a proprietary procedure, and so was unwilling to agree to that. I mean, you have, and GFL has provided copies of the site as it is now, and copies of the other documents were produced in the court proceedings of other dates of drone reports. Sure. Mr. Francis indicated there was no sulfur at the facility, and that had been done in response to the concerns of stakeholders, and that while they weren't felt they were unable to meet all of the requests of NAP, this has been presented as requests of NAP, they were dedicated to building a positive relationship with Wheatland and its residents. And GFL proposed a third-party facilitated meeting in the week of June 17th. That meeting appears never to have occurred. And then in June, later in June, GFL prepared its report. They did a community report, and that's essentially describing the current status of the facility. And there were a number of things reported on in that, including the progress that was being made on the legacy pile, and at that point, it looked like there was going to take some considerable more time to deal with it.
Excuse me, Mr. Robertson. Could I just interject with a question? We have a number of members of the community surrounding GFL here today. Could I just by a show of hands see who received that report in June that Mr. Robertson is referencing? Thank you. Carry on. Our council did receive a copy through our MLA's office.
I may, if there's a break, I may be able to talk to Mr. McCara and see if he has any more information on that. I may be able on a break to talk to Mr. McCara and see if he has any more information on that, on
Thank you.
how it was delivered. But there was on at that point, there appears to have been a lapse of communication. What we understand from Mr. Henderson's transcript of cross-examination is that he had a meeting with Mr. Huckstead and his wife and some others on June 27th, and that as a result of that meeting, he went and did called it an inspection of the facility from the road. He didn't make any inquiries of GFL as a result of that, but there was the orders were prepared shortly after that, and they were issued, obviously, following the July 2nd, 2019 council meeting. Now, of course, that led to those were the orders that we're dealing with today, or two of them. Now, in the transcript of Mr. Henderson's questioning, which was done on July 29th, a copy of his transcript is in your materials provided by the county, sorry, by the administration. Let's get the tab number for you.
The tabs don't show on our PDF, so page numbers are more helpful for council. I believe it's a separate attachment, though we have it just separate. Oh, sorry, that is tabbed, yes, sorry. It's
Tab H?
Thompson Millers that is not tabbed, yeah.
Okay. So, and this information is found at Mr. Henderson's transcript, page 22, lines 23 to page 23, lines 3. Mr. Henderson indicated that the Wheatland had issued a stop order under its land use bylaw and the Municipal Government Act and remedial order pursuant to the nuisance bylaw and the MGA. Sorry, I'm saying that. But Mr. Henderson admitted that those orders were issued in that way together. They were part of a strategy. They were intended to work together to have the greatest impact on GFL. Now, in the preamble to the July 3rd remedial order, Mr. Henderson stated that he inspected the property on June 27 and 2019, observed violations of sections 3.2, 3.4, and 3.5 of the nuisance bylaw and 546 of the Municipal Government Act. He says he received and inspected a third-party technical assessment report entitled GFL Composting Facility Assessment, which is the report that was prepared by Dr. McCartney in 2019 without having visited the site. He indicates that his inspections revealed the following conditions which were not authorized by the registration, and refers to noxious odors emitting from the property, release of substances producing a leachate pond on the property, acceptance and storage of greater than 100 tons of elemental sulfur at the property, acceptance of greater than 20,000 tons of feedstock annually at the property, storage of waste at the property, and failure to properly dispose of feedstock requiring reprocessing, i.e. the legacy pile. But on cross-examination, Mr. Henderson admitted that he did not observe any sulfur on the facility at the time of his inspection on June 27, or at the time he entered the facility later on July 11 of 2019. And of course, that's because there was no sulfur on the facility and had not been for a considerable period of time, dating back well into the previous year. He agreed that there had never been, to his knowledge, an incident of leachate escaping from the facility, that he was not qualified to assess the likelihood of anything escaping from the leachate pond, and that Alberta Environment and Parks was qualified and had the responsibility to assess whether there was likelihood of escape from the leachate pond. He agreed there was no evidence that GFL had ever accepted greater than 20,000 tons of feedstock at the facility. He did not know that, and GFL has confirmed that it is not. And he confirmed that the issues cited in the orders were based on complaints of odors dating back, in some cases, to 2016. At the time that he issued the remedial order, aside from his inspection from the road on June 27, Mr. Henderson did not investigate any of the complaints, and he didn't know if any of the complaints had been investigated to confirm such factors as wind direction. And so there's, our first point about the order and reasons why it should be canceled is that the information that Mr. Henderson said he observed from his inspection is simply not there. And remember that he's talking about a nuisance here. He's talking about something that is on the property that needs to be ameliorated. And there's actually no indication that any of these relate to anything except there is a reference to the legacy pile. That is, and on cross-examination, Mr. Henderson indicated that storage of waste, by storage of waste, he meant the legacy pile. So most of the items in the list are included, and they're actually not accurate. They're not factual. They may have happened at one point in the past with respect to sulfur being stored on the site, but it had not been that case for a long time. And I'd suggest that if something is a nuisance, it's not you can't issue a remedial order for something that has already been remediated. Now, the remedial order and the stop orders contain the first 6 directions are identical, or virtually identical. GFL is to stop accepting feedstock or other organic material to property within 90 days, removing or processing and removing all feedstock on site, including the legacy pile. Immediately ceasing carrying on any activities that are not expressly authorized by the registration. And again, there's a reference to the registration. And I'll come back to mention that again when we're talking about what we suggest is overstep by county administration to the role of AEP. Well, there's unquestionably a nuisance jurisdiction within the county. With the information that's being requested and the fact that it is not related to the issue which Mr. Henderson indicated, all of his descriptions, especially in the, well, in both orders, refer to is being the legacy pile. They go far beyond that. There's no reason for asking for them. And what the administration seems to be attempting to do is to determine whether or not GFL is in compliance with its registration, which is issued by AEP and administered by AEP. And as recently as July 16th, we have the comments of Mr. Jorgensen. Again, both orders request progress reports on the removal or reprocessing of the legacy pile of feedstock, to take all lawful measures needed to ensure that leachate is not released from the property. That's a requirement that is expressly or impliedly included in the, it's the purpose of a leachate pond. And to develop and implement an air monitoring program satisfactory to the Chief Administrative Officer. So there are these, those things are in common to both orders. The July 3rd remedial order requires the results of air monitoring programs to be delivered on a bi-weekly basis and to implement a documented odor contingency response plan, and then to deliver the operations plan, odor management program, and groundwater monitoring program, and any results arising therefrom. Now, again, those are all reports that are required to be provided to Alberta Environment because Alberta Environment uses them to regulate. Alberta Environment reviews them and acts on issues that arise from them, if any. In this case, there weren't any. The groundwater report has actually been provided. Mr. Henderson was provided with a copy in July. And then there were a further request for records relating to acceptance of feedstock and release, disposal, date, or dispossession by any means of compost or other organic material from the property for the last 5 years. And again, if we're talking about ameliorating a nuisance, going back 5 years doesn't really seem to have any relationship to that issue. It goes beyond. Then on July 5th of 2018, we have the further remedial order, and having been told to remove and reprocess the legacy pile within 90 days, they're now told to immediately cease any activity at the property that would cause ground disturbance until further notice by the county, and to immediately cease any actions removing any materials, including soils or liquids, from the site. And then, upon receipt of notice from the county, remove and process and remove all feedstock on site, including the legacy pile, then, and provides the rest of it remains in force. So this order then, in addition to these other, the requirements about reporting, and that it requires that, and allowing access, it requires GFL to stop doing everything. And so they're inconsistent with each other. They're saved from being inconsistent by the, or would have been saved from being inconsistent by the fact that the second orders are to be done until such a date, but or they'd be partially saved. But the difficulty is that there's now an order from Justice Ho that says that you're not going to be doing this inspection. And the inspection, the order that was sought by the county for inspection also requested the ability to take samples and seize documents and require questions to be answered. In our submission, they're aimed at collecting data that have nothing to do with the legacy pile and which are monitored and confirmed to have been non-issues by Alberta Energy and Parks. So in our submission, they overreach. They go further than necessary for a nuisance order, and they appear to seek to regulate GFL's activity. Now, with respect to the question of whether the legacy pile can be a nuisance when it has been where it is for as long as it has been, well prior to GFL's ownership of the facility. I would observe that that what is clear is that the legacy pile appears to create the worst smells when someone is trying to deal with it. And the faster they try to deal with it, the worse it is. So it's in a sense, it's less of a nuisance if it's sitting there than it is if you're actually trying to get rid of it. And as you've seen over there'll be some disagreement from the administration, but there were over 2018 far fewer complaints than there had been in the past, and that's something that's noted by Mr. Jorgensen. And one of the reasons for that is the speed with which the legacy pile was being processed. And
That's conjecture on why there would be less written complaints. So I respect what you said, but that's conjecture.
well,
You can't ascertain why there would be less written complaints.
no, I can only say that in the period when GFL was processing the legacy pile at a slower rate than they had, say, in 2016, than the predecessor had in 2016, that there were fewer complaints.
And there could be a multitude of reasons for that. If I could just ask you a question.
Sure.
So as council's reviewing this, we're cognizant that we have responsibility under the MGA to pass bylaws for municipal purposes respecting the following matters: the safety, health, and welfare of people, and the protection of people and property, nuisances including unsightly property. Under our unsightly bylaw, the owner or occupant of a property shall not cause, allow, nor permit that property to be either in an unsafe condition or in an unsightly property. So I'm wondering why GFL has not permitted Wheatland County staff, administration, or consultants on site to do testing so that we can establish that the site is safe. You've made this statement, you've asserted multiple times today that there's no sulfur on site, and yet previously you described gypsum that was found under a berm, sort of incidentally. So how am I, on behalf of our ratepayers, to understand that information, that there's materials discovered on site that purportedly GFL was unaware of? So why does GFL not allow our staff on site to conduct the testing required for our bylaw?
The reason for resistance on that issue is because of the lack of preference to be governed by Alberta Environment, because Alberta Environment is an expert regulator.
And I understand jurisdiction, and we under no circumstances intend to take Alberta Environment and Parks jurisdiction in terms of regulating this compost.
Well,
we do have concurrent jurisdiction, particularly over things like nuisance. And that's what administration was acting upon, was cumulative effect of complaints, particularly surrounding things like odors and other nuisances that were identified. So there is concurrent jurisdiction that's been established.
with respect to nuisance, there is, but if you look at your bylaw, you'll say you'll see that it says to permit. I just have to get the wording.
You'll also see under our bylaw under 3.15, no person may obstruct, hinder, interfere, or impede the chief administrative officer or an officer in the performance of his or her lawful duty, the exercise of the chief administrative officer or officer's powers, or any person acting under the direction of the chief administrative officer or an officer in relation to this bylaw.
And the remedy for the officer who feels that they are impeded is to apply to the Court of Queen's Bench under Section 543 of the Municipal Government Act. And if the court declines that application, then they are not allowed on the property. And that is what happened here.
Do you have further response to why they were denied?
Simply because, for the reasons I mentioned, there's concern that, for example, if the Alberta Environment Parks is an expert regulator, the county GFL's view is that the kind of detailed inspection that's proposed in these orders, and for the purposes that's proposed in these orders, that is that it's for the amongst other things, it appears to be to determine if GFL is in compliance with its registration. It could, if it acquiesces to that, could find itself in a position where it is improperly regulated by the county with respect to, because the county is not an expert body on environmental issues, which has been acknowledged. The county ends up hiring a third-party expert, and then GFL is at the mercy of that third-party expert, who it has no input into selecting, that is not, doesn't have it's not being engaged by an expert regulator. So, for example, like when Alberta Environment, and I mean, it has its own policies and standards. Obviously, it is the agency itself, and the people who work for it are all experts. So there's consistency. So whereas in that scenario, and all of the experts who, like GFL was not consulted in the expert chosen. An expert was selected and said, and on any occasion when it was proposed that an expert would come on site, it was just, GFL was told, we want this person to come on site. And so there's real concern about an individual expert having a view that may diverge from what the same standards that Alberta Environment might impose, so that you could have an anomalous situation.
Yeah, you can proceed.
I mean, and ultimately, to be fair, the Municipal Government Act sets out the circumstances under which a municipality can enter onto the property, and in this case, there has to be a right in the bylaw, and there has to be if there is resistance, then there is a remedy. In this case, the remedy was exercised, and the court said no. Now, in that application, it was suggested that this was not in connection with the orders, that it was a new application, but it was based on complaints that were even older than the ones that were referenced in the actual orders. And that was commented on by Justice Ho as well. So there was, this order may have been, and it was actually filed in our judicial review application. But the purpose of that portion of the Municipal Government Act is to give the court oversight over entry to property, and as we've indicated in our materials, that access without that authorization is a trespass. So it's necessary to have the court order to allow access in those circumstances for an inspection, which the county clearly understood because it made that application, and the result was that the application was denied. So there are reasons that those provisions exist, and so upholding them upholds not just the rights of GFL in this particular circumstances, but the rights to everybody to be left alone on their property and not subject to inappropriate interference. So there is oversight. As is often the case, it's not just about the party in front of you, but it's about everybody. Amongst the documents that were provided by the county, there's a memo to file, which we obviously had not seen before. And it, I would assume, was prepared sometime after June of 2017 because the title of the document is Compost Facility Green for Life. So it would obviously date from after the acquisition of the site by GFL. But it goes back to 1997. It actually provides some quite a bit of information about the history of the site and the fact that odor has been associated with the site in different forms for a long time, and but it has been a concern, but it has not been. It has not had such an order issued in the past. There were also a number of occasions when advice was sought from the county's previous council with respect to the jurisdiction of the county, and her advice was consistently that there were obviously limits. And the county has acted on that in the past. Now there are, in the memo, there are a number of, there is no author to the memo, so we don't know who prepared the memo or what the purpose was. Many of the statements are not provided in what you might call a neutral manner. But there's a signature by Susan Hayes at the end, but it isn't clear what the source of the information is in all cases. We don't know if that's Ms. Hayes' recollection or if she's referring to documents or what the circumstances are. But I think the perhaps most significant comment I have coming from the memorandum is that there's is that the question has been considered, the question of the jurisdiction of the county has been considered many times, and until this year, it appears to have consistently taken the view that it did not have jurisdiction over environmental matters. One of the documents that the council for the administration provided was a copy of a fire report, and this is just recent, and it's from the 19th of August. I've provided you with a copy of GFL's incident report with respect to the incident. The striking thing appears to be that the fire, which was a small fire, occurred as a result of one of the bird bangers that they have to scare away seagulls. There was a spark flew and got caught by the wind and was carried into some hay, and the hay got on fire apparently, and that resulted in a burned area about the size described to Mr. Wall by his employee as an area about as big as the hood on a truck, and it was put out with fire extinguishers and smothering. It was out within 15 minutes. The call to the fire department came 2 hours later. Somebody called in a fire and said there was a fire at the site 2 hours after it had been put out. And the details of the attendance are set out in the report. The fire department did attend, but not as my understanding is not with trucks, but just the fire chief, regional fire chief, Mac de Beaudrop, came out and reviewed the site. But there was no fire to be fought. Some suggestions were given, which were followed, and change in procedure made so that in future when they're using the bird frighteners, they'll do that over the leachate pond so that there's less risk of anything catching fire. So that's the extent of that event. But at this point, there are cameras positioned permanently in the field adjacent to GFL. There are aircraft flying over and taking photographs, apparently taking photographs, and drones. And so there's appears to be a desire to take anything like this and try to make an issue of it. But I suggest that the focus of this hearing should be on the appropriateness of the orders that were issued, whether the county considers that it has the jurisdiction to issue the orders that were issued, if it's in a position to suggest, if it wants to suggest changes, to suggest changes without having the issues clarified, or even reviewing the reasons of Justice Ho, which, as I've said, will have we believe and submit will have an impact on the effect of the orders themselves and create further confusion. But if there's the focus in my submission of this application, of this appeal, it needs to be should be on the appropriateness of the orders, the jurisdiction of the county to issue the orders, and whether the orders as issued and according to the statements under which the facts under which they say they were issued were appropriately issued or need to be modified. In our respectful submission, we would ask that the remedial order, both of the remedial orders, be canceled.
Thank you. We'll now hear from Wheatland County Administration.
Thank you, Madam Reeve. My name is David McGilvery. I'm counsel with Gowlings here on behalf of county administration. Members of Council, I have submissions to certain arguments that Mr. Robin has presented to you today. However, and more importantly, I will present to you a summary of County Administration's views on the facts and laws that you should consider when deciding the outcome of the review of the remedial orders that are at issue today. The Council should uphold the remedial orders issued on July 3rd and 5th to GFL and Ms. Cleve for what I would submit are 5 main reasons. In our respectful submission, each of these reasons is sufficient to dismiss the reviews and uphold the remedial orders. I will address each of these in more detail, but at the outset, I think it would benefit for me from stating, for the record, my general roadmap of what it is that I intend to submit. Firstly, pursuant to Section 547(1)(b) of the Municipal Government Act, the owner and occupant, in this case GFL, and Ms. Cleve, are time barred from seeking review of the remedial orders issued under authority of Section 546 of the MGA. The owner and occupant had to seek review in respect of unsightly conditions within 7 days of being served, which they did not do so. In our respectful submission, that entitles them from any remedy in respect of that provision, or in respect of the aspects of the orders that go to unsightly conditions. Second, GFL caused, allowed, or permitted the property or the use of the property to constitute a nuisance, contrary to Section 3.2 of the Nuisance and Unsightly Property Bylaw. I know we've discussed what the definition of this is, but I'll repeat it just for clarity. Nuisance means any condition or unauthorized use of property which, in the opinion of the Chief Administrative Officer or an officer, constitutes an unreasonable interference with the enjoyment, use, or value of other property or the quality of life of county residents. And I would submit that there are 3 main nuisances from this property that should be considered in the context of Section 3.2 of the Nuisance and Unsightly Property Bylaw. First, in our submission, GFL was not authorized to store composting materials anywhere on the property without processing them within a reasonable period of time. There is no express right in the AEP registration to store any composting material on the site for any amount of time. Any implied right to store composting materials on the site would be limited in time to a reasonable period to actively process them into compost products. The storage of composting material in the form of the legacy pile is not an authorized use, and it is a nuisance. Secondly, GFL was not authorized to store anything on site that is not composting material. For at least the last 7 years, the legacy piles on the property contain non-composting materials, including plastic waste. The plastic waste in the legacy piles is there because they contain feedstock that was accepted onto the property without first separating organic waste from plastic packaging. There is no express or an implied right in the AEP registration to store any non-composting materials on site, period. This storage of plastic and other non-composting materials in the legacy piles is not an authorized use, and it is rightly a nuisance. Thirdly, there is no express right in the AEP registration to admit or release any foul odors from the property at any time. Any implied right to release foul odors from the property would be limited to the time and stench to the fresh organic waste, which GFL refers to a large degree in the cross-examination of Mr. Francis that had occurred in the context of the court proceedings. And so we would accept that there's a low level of odor that may impliedly be authorized, but the extent of the emissions that we're dealing with here are not. The third general reason why the remedial orders should be upheld is that GFL caused, allowed, or permitted the property to be an unsightly property contrary to section 3.4 of the nuisance bylaw. Unsightly property clearly shows signs of neglect or which otherwise exhibits a significant lack of general maintenance, cleanup, or upkeep, and includes the GFL property having an excessive, unusual, unreasonable accumulation of refuse and plastics. In our submission, the contents of the legacy pile go to this point. Further, GFL, in our submission, allowed or permitted the property to remain a nuisance or unsightly property contrary to section 3.5 of the nuisance bylaw. And finally, it is our position that in the opinion of the designated officers, the property was, because of its unsightly conditions, detrimental to the surrounding area, contrary to section 546 of the MGA. I know that the council is quite well versed in the general facts of the situation that we're considering today. But I will give some key facts and backgrounds for context, and also to better convey how county administration understands the situation that we arrived at today. As detailed in tab B of the materials, which includes various complaint logs as well as in the affidavit of Brian Henderson, which was filed in the context of related court proceedings, which is included at tab G. Over the course of the past several years, residents have complained about various nuisances arising from the facility, including but not limited to noxious odors emanating from the facility, the presence of birds and insects around the facility, the presence of sulfur and drywall on site, and the litter escaping from the facility. As noted in the transcript of Mr. Henderson's cross-examination, which is at tab H, and perhaps we could go to page 21. And in terms of his response at lines 15 and then on to page 22 up to line 6, it's very clear that some residents have made formal complaints to the county. However, there have also been a significant number of informal complaints that were not tracked, including complaints made by way of phone calls or appearances in this very council chamber. As detailed in Mr. Francis's affidavit at tab E, and paragraph 3 in particular, since the facility's inception, it has changed hands on 3 occasions, first in 2011 to a company called Biocycle, then in 2015, and then ultimately to GFL on June 1st of 2017. At or around the time that Biocycle acquired the facility in 2011, the operator of the facility began storing large quantities of drywall and off-spec sulfur at the facility and adding it to the compost materials. Off-spec sulfur is elemental sulfur derived from petroleum and natural gas production that is undesirable for industrial purposes. Neither sulfur nor drywall are organic material, as they contain no carbon. Further, as detailed at paragraph 17 and 18 of Mr. Francis's affidavit, for a period of time, Biocycle was producing a product called Biosol, which is composed of 70% sulfur and was marketed to farmers in the county. A picture of the extent of the sulfur on site as of May 3rd of 2017 is included in tab, I think it's either I or L of the materials that were provided, and perhaps we could pull that up for.
Image 5429.
4599.
So this, just for context, is a photo of sulfur that was on site as of May 3rd of 2017. Notwithstanding transfers in ownership, residents' complaints about the various nuisances arising from the facility have continued. Specifically, piles of unfinished compost, the legacy piles, have been a major source of the noxious odors. According to GFL, as detailed in paragraph 33 and Exhibit N of Mr. Francis's affidavit, at the time that GFL acquired the facility, approximately 12,000 tons of material were in the legacy pile, in addition to off-spec sulfur and drywall. GFL developed an action plan, which has been discussed and can be found at tab B of GFL's request for review, in an effort to address many of the concerns of residents when it acquired the facility. Specifically, the action plan contemplated that the legacy piles would be completely removed from the facility by March 3rd of 2018. However, by January 2nd of 2018, very little of the legacy pile had been removed from the facility, and GFL revised its forecast such that half of the legacy pile would be removed by the end of April of 2018, and the remaining half would be removed by the end of April of 2019. As detailed in Mr. Francis's affidavit at paragraph 33, and further, I would also make reference to the transcript of Mr. Henderson's cross-examination, which is at tab H, pages 18 and 19. At the time that the county issued the July 3rd and 5th orders, less than half of the legacy pile had been removed from the facility. Making matters worse, GFL estimated that it would take another 20 months to address the remaining portions of the legacy pile. This may not include operating over the winter months, resulting in timelines closer to what could be up to 3 years before the legacy piles are completely removed. GFL's failure to adhere to its own promised timelines for addressing the legacy pile has been of great concern for the county and county administration. The action plan also contemplated that all of the drywall would be blended with compost and shipped to end users by 2018, and that all of the sulfur would be blended with compost and shipped to end users by August 31st of 2017. Only 2 months after the action plan was distributed, unfortunately, the last stores of salts were not removed from the facility until September of 2018, as we understand it, and the gypsum was not totally removed from the facility until after the orders were issued. The removal of both sulfur and the gypsum were more than a year behind schedule, which only exacerbated the residents' discord with GFL. Given the ongoing concerns regarding the legacy pile and the nuisances caused by the facility, the county retained Dr. Daryl McCartney, a professor with the University of Alberta, whose CV I provided last night. I think it was supposed to be included in the materials initially. And he was retained to conduct an assessment of the facility in an effort to deal with the root causes of the odors and further understand the local residents' concerns. Dr. McCartney ultimately prepared a report, which is included at tab C of the package of materials we provided. As noted in the remedial orders, the report served in part to inform the issuance of the orders. As detailed in Mr. Henderson's cross-examination at page 18, page 18, lines 1 through 10, on June 27th, Mr. Henderson received a complaint from a group of residents regarding the noxious odors from the facility. In response to this complaint, Mr. Henderson drove to the theater later that day to conduct an external inspection of the facility. Based on Mr. Henderson's observations during the June 27th inspection, the county issued a remedial order against GFL and Ms. Cleve pursuant to the nuisance bylaw and Part 13, Division 4 of the MGA. On the same day, the county also issued stop orders against GFL and Ms. Cleve pursuant to the MGA and the land use bylaw, which are the subject of another proceeding. On or about July 4th of 2019, GFL, through its legal counsel, advised the county's council that it considered the July 3rd orders to be invalid and unenforceable and would therefore continue to operate the facility. And so on July 5th of 2019, the county issued additional remedial orders against GFL and Ms. Cleve, the July 5th orders, to ensure and restore compliance with the MGL and the nuisance bylaw. The directions set out in the July 15 are substantially the same as those in the July 3rd orders. And contrary to the submissions of my friend, they can be read in concert with one another. And in fact, it's quite clear on reading them together that the first couple of provisions within the July 5th order supersede and replace aspects of the July 3rd order, which is quite clear in our read of it. We would further note that from the county administration's respectful submission, GFL continues to operate the facility in contravention of the July 3rd and July 5th orders on the basis that it considers the orders to be invalid and enforceable. It has done so even though its application for a stay of those orders before the Court of Queen's Bench was dismissed. Now, my friend has talked at some length about the need for our written transcript from those proceedings, and as well as further advice and direction in respect of an application that he may bring. He indicated that he will, but that hasn't been done. In any event, I think that he's mischaracterizing the order to some degree, or the decision of Justice Ho to some degree, and it's in this respect is that the application that was brought under Section 543 of the MGA, I believe, was an application in respect of a statutory injunction to enter the property for the purposes of carrying out those inspections, which application was denied. But she also did not grant a stay of the application of this proceeding, and I would put to you that she has not pronounced upon the ability to enforce whatever orders come out of this process. She has not pronounced that there is no way and under any circumstances that an inspection cannot occur. She has simply denied an application in respect of what was brought purely in the respect of what we believe was a statutory right, but she felt that it was discretionary. So I don't think it's accurate to suggest that the decision of Justice Ho means that there can never be access to the property. But further, I would suggest that I guess, I mean, I've sort of made the submission, but I think that there is it isn't a final pronouncement on the ability to enforce the orders. In fact, she gave a stay, or she didn't give a stay in respect of not that would restrain this process. So whatever comes out of this process, what is in those orders is still potentially valid. I'll now turn to engagement with Wheatland Council, a discussion of engagement with Wheatland Council and community. GFL has talked a lot about, at least from its perspective, how it has made efforts to try to engage and work collaboratively to some degree since having purchased the facility. And we would put to you that this is certainly one side of the story. As noted by GFL, it developed, and collaboratively with JFP and the county, an action plan shortly after having purchased the facility. However, since that time, GFL has revised its proposed completion time for processing the legacy pile, and these revisions have been made without the input of county. A summary of this is as follows. On December 11th, 2017, there was a letter from county to GFL, which I believe is tab D, I want to say D of the materials that are included within the review request. And that's a warning letter issued under certain powers under the nuisance bylaw. It outlines problems with garbage and debris on a landowner's property. Sorry? Tab E, sorry, thank you. It talks about how, GFL does eventually clean these things up, but the flow of debris must stop and that it constitutes a nuisance. It outlines concerns about drywall dust being a nuisance, and it indicates that these nuisances must stop by July 31st of 2018. Sorry, January 31st, 2018. Apparently I'm dyslexic. Okay. On July 2nd, 2018, a letter from GFL was given to the county, which I believe might be the next tab. And thank you, F. And GFL has indicated that it's doing what it can to stop the flow of debris. It indicates that GFL does not agree that incidental, as it puts it, litter and drywall dust constitute a nuisance. We'll deal with, and that in dealing with the legacy pile by April 30th of 2019, that will remove a lot of the incidental litter. It talks about how it will remove the drywall pile by April 30th of 2018, which I would note is 3 months after the deadline set by the county in the original outset, and will install higher fencing by February 28th, 2018, 1 month after the deadline set by the county. So in GFL's response, it's already showing an intransigence. I mean, the county has indicated that they're a nuisance, and GFL's response is, we disagree. On May 3rd of 2018, there was a letter from GFL to county, and in that letter, they informed that they're not going to allow Dr. McCartney in to inspect, Dr. McCartney in the site to inspect. The county does not have jurisdiction to regulate, and that it has been working with EAP. So again, you've got a situation where the county is proposing something, I would note that, given the history of this site and the concerns of citizens, there is, I think it's fair to say, and I imagine when people from the community get an opportunity to speak, that it may come through in this, but there's a concern about lack of transparency, and with lack of transparency, there's a lack of trust. And I would suggest that GFL there's no reason that it would need to block, an assessment which really has lofty or reasonable goals by an expert in the field. And on May 7th of 2018, there's a letter from council to the county to council to GFL. And in that letter, it indicates that GFL failed to meet its targets for both the fencing and the legacy piles. It indicates that GFL's continuing failure to meet its targets makes people think that it's not making its best efforts, it's not following through, and that there had been 2 further odor complaints formal order complaints, I would note. So then on May 18th of 2018, there's a letter from council to GFL to council to the county. And in that, it highlights that GFL never set hard commitments for processing legacy pile. It notes that 20% of the legacy pile had been processed and that the remainder should be done by April 30th of 2019. It says that GFL has ordered and installed a fence to stop the flow of plastic debris, and GFL has effectively unilaterally determined that the odor complaints must have come from something else. Also, it was apparently informed that there had not been any complaints for several months. In each case, GFL is largely dismissive of the county's concerns, particularly in respect of the pace of processing the legacy pile in the May 11th letter. This approach, however, is consistent with GFL's conduct to date. GFL has shown no respect for the county's authority or to the commitments it makes to the county. When the county issued the remedial orders on July 3rd and 5th, GFL operated in contravention almost immediately thereafter. Even after Justice Ho of the Court of Queen's Bench stated that it was inappropriate for GFL to ignore the remedial orders, and in fact, that was one of the bases for which their application was denied, GFL continues to operate, in our view, in contravention beginning as of last week. GFL's engagement with the county has been nothing short of deplorable. GFL has also noted that one of the causes for delay in processing the legacy piles was a fire that took place on October of 2017. GFL takes time to note that this fire was investigated as a possible arson by the Wheatland West Fire Department, but of course, they do not state that the fire department concluded that the fire was they do not state that the fire department made any conclusion that the fire was caused by arson, because the fire department never came to that conclusion. In fact, the fire in October of 2017 is not the only recent incident of fire at the facility, as has been discussed. As we understand, there has been one as recently as last week. It appears as though fires at the facility are somewhat of a common occurrence. So it's peculiar that GFL would make any suggestion that any fire at the facility may have been caused by arson, as fortunately this seems to be the state of affairs between GFL and the residents of the county. In short, GFL's community engagement has left a lot to be desired. Although poor community engagement is not a ground for the issuance of the remedial orders, the county's administration submits that GFL should not be afforded any leniency on the basis that it has been brazenly ignored the county's authority to date. Now I'll turn briefly to discuss the issue of jurisdiction of Wheatland County and County Council. A theme of GFL's submissions in this and related proceedings is that the county, in issuing the orders, has acted with an improper purpose and is acting outside of its jurisdiction. In taking this position, GFL would have council believe that the regulation of its facility, at least insofar as the order is concerned, fall exclusively within the jurisdiction of Alberta Environment and Parks. We disagree. County administration respectively submits that there is necessarily some overlap between the jurisdiction of the county, as enabled by the MPA and its bylaws, and the purview of the province. To be clear, municipalities are given broad remedial powers to regulate matters within their respective municipalities. Under Section 3 of the MGA, which deals with municipal purposes, it states the purpose of a municipality are A, to provide good government, A.1, to foster the well-being of the environment, C, to develop and maintain safe and viable communities, and D, to work collaboratively with neighboring municipalities to plan, deliver, and fund intermunicipal services. Under Section 7 of the MGA, a council may pass bylaws for municipal purposes respecting a number of matters, including, but not limited to, the safety, health, and welfare of people and the protection of people and property, nuisances, including unsightly property, businesses, business activities, and persons engaged in businesses, and the enforcement of bylaws. Furthermore, Section 9 of the MGA enacts further broad municipal powers and provides the power to pass bylaws under this division is stated in general terms to A, give broad authority to councils and to respect their right to govern municipalities in whatever way the council considers appropriate within the jurisdiction given to them under this or any other enactment, and B, enhance the ability of councils to respond to present and future issues in their municipalities. In the present circumstances, Wheatland County has validly enacted the County Nuisance and Unsightly Property Bylaw on the basis of powers expressly given pursuant to the MGA. Under the nuisance bylaw, nuisance is defined as any condition or unauthorized use of property which, in the opinion of the Chief Administration Officer or an officer, constitutes an unreasonable interference with the enjoyment, use, or value of other property or the quality of life of county residents. Further, unsightly property is defined as any property or part thereof that clearly shows signs of neglect or which otherwise exhibits a significant lack of general maintenance, cleanup, or upkeep, and includes property having an excessive, unusual, or unreasonable accumulation of things like refuge, garbage, piles of soil, clay or rubble, petroleum products, plastics, used containers, paper products, or any other form of scrap, litter, trash, junk, or waste of any kind. In the county's administration's respective submission, the orders issued pursuant to the nuisance bylaw clearly fall within the powers of the county as authorized by the MGA. In this regard, courts have consistently noted that wherever possible, municipal bylaw and provincial laws should be read in harmony to allow overlapping regulation. The Supreme Court of Canada has noted a clear and obvious conflict in substance or purpose is required before a municipal law and provincial law, but between a municipal law and provincial law to find that a municipal law cannot operate. The governing code of conduct, which forms part of GFL's registration to operate a Class 1 compost facility, as issued by AEP, is silent with regard to the storage of waste. At best, it's permissible about vague regarding the issues that have arisen in regards to the facility, including odor control. As will be discussed in greater detail in my submissions to follow, the presence of the legacy piles, as well as other inorganic substances, are not expressly authorized by GFL's registration or the code, and as such, it is lawful and in fact reasonable for the county to regulate it or otherwise enhance the permissive nuisance and odor provisions of the code. Wheatland County's actions in the matter align with its purposes and mandate, as well as the authority given to the county by statute. Further, any submission by GFL that county does not have the authority to make a remedial order that would arguably conflict with an action provincially authorized under the registration is not a question of jurisdiction, and it's framed as a question of jurisdiction in their request for review. It's in fact a question of law. The Supreme Court of Canada has clearly explained that questions of jurisdiction only arise where a decision maker does not even have legislative authority to enter into the inquiry, keyword being inquiry, that led to the order in dispute. Not even GFL would argue that the county had no authority to inquire into the public complaints of nuisance conditions on and coming from the site. GFL's argument is that after investigation of the site, the county did not have the power to make the remedial orders that it made. This is a question of law, not jurisdiction. GFL is mistaken to have argued this, that there is any question of jurisdiction before this council. With regard so I'll now turn to, which is I guess the first reason that I outlined for upholding the orders, and that is, at least insofar as the unsightly conditions component of the orders is concerned, under Section 541 of the MGA, a person who receives a written order under Section 545 or 5 may by written notice request council to review the order within, and for the case of 545, 14 days, and within the case of 546, 7 days. The orders were issued under authority of Section 545. Those are the parts that deal with the breach of the nuisance bylaw. And Section 546, the parts relating to the breach of the Municipal Government Act. GFL's request for review was delivered to county on July 17th, which is more than 7 days, but within 14 days after the date the remedial orders were served on GFL. GFL's request to review the parts of the remedial order issued under authority of Section 545, those relating to the breach of the nuisance bylaw, were arguably brought in time and can be considered by council. However, GFL's request to review the parts of the remedial orders issued under authority of Section 546 relating to the breach of the Municipal Government Act for having unsightly conditions on the property were brought out of time and must be dismissed by council. The MGA does not provide any discretion to extend this time. It's a hard deadline provided by legislation, and GFL did not meet the legal deadline. As I will argue later in my submissions, all parts of the remedial order should be upheld by council because there is merit to them. The significance of GFL's missed deadline is as follows. Even if the parts of the remedial order finding a breach of the MGA did not have merit, GFL's challenge to those parts must fail. Otherwise said, GFL is not legally able to challenge today that it breached Section 546 of the MGA. The consequences of that is significant. The relevant portion of 546(1)(c) of the MGA provides that if, in the opinion of a designated officer, property, because of its unsightly condition, is detrimental to the surrounding area, the designated officer may, by written order, require the owner of the property that is in an unsightly condition to improve the appearance of the property in the manner specified. That is, of course, what the remedial orders are seeking to do. They require GFL to clean up the property in the manner specified in the orders, in particular by removing the legacy pile materials from the site within 90 days of the orders. This part of the remedial order stands unchallenged because GFL did not bring its review challenge before the legal deadline. Next, I will move on to our points on the notion that GFL and Ms. Cleave caused, allowed, or permitted the property or the use of the property to constitute a nuisance contrary to Section 3.2 of the nuisance bylaw. As summarized briefly at the outset of our submissions, there are at least 3 nuisances arising from the property. Firstly, in our respectful submission, GFL was not authorized to store composting material anywhere on the property without processing them within a reasonable time. GFL takes the position that pursuant to the registration, it is entitled to accept 20,000 tons of waste per year, and waste that accumulates to form the legacy pile was counted in the years that it was accepted. Therefore, from GFL's perspective, the processing of the legacy piles in subsequent years does not count towards the 20,000 ton annual limit. In other words, the 20,000 tons of waste per year threshold is not a throughput. The county accepts and understands that a Class 1 compost facility that accepts not more than 20,000 tons of waste per year is subject only to a registration rather than approval from Alberta Environmental Parks. However, the code, as well as any other relevant provincial legislation, is entirely silent on the storage of waste or feedstock in the context of the operation of a Class 1 compost facility. On the basis of GSL's interpretation of the requirements, it would be acceptable for a facility to simply accumulate waste at a rate of 20,000 tons per year without regard to output from the facility. With respect, this is absurd. In the McCartney report, at point 17 of page 9, when referring to the legacy pile, it states, technically, this material should be considered waste materials feedstock and should be included in the 20,000 ton per year input limit to the site. The rationale for this is the composting process on site is designated to handle 20,000 tons per year of feedstock. It will not have the capacity to treat additional material requiring reprocessing plus fresh feedstock material. However, the code of practice does not cover this specific problem. Following best practices, a design and operations plan should have been developed to determine how this will be accomplished. There is no express right in the AEP restoration to store any composting material on site for any amount of time. Further, we submit that any implied right to store composting materials on site would be limited in time to a reasonable period to actively process them into compost products. On this point, I'll now turn briefly to the affidavit of Donald Francis at tab E. And specifically, if we could go to paragraph 81, or sorry, 82. And there he states, GFL is not stockpiling feedstock or other organic matter. It receives feedstock and processes it as it is received. The composting process usually begins the same day, and occasionally feedstock might wait 48 hours before it is mixed into a compost bunker. If this is a reference to the legacy pile, it was in place in 2012 when Wheatland County informed the facility operator and the landowner that a development permit was not required. By GFL's own admission, in the ordinary course, feedstock might wait 48 hours before processing is commenced. Furthermore, representatives of the operator have previously informed council in this very chamber that the legacy pile could be removed in a period of six weeks or 3 months. And in this regard, the approximately 7 years that the legacy pile has awaited processing is entirely unreasonable. Mr. Francis was cross-examined in connection with his affidavit, and a transcript, and the transcript of which can be found at tab F. And on the issue of the legacy pile, at page 24, lines 12 through 19, when asked about why the legacy site pile existed at all, Mr. Francis stated, it was not composted correctly. The piles weren't built to facilitate proper composting to a finished, stable product. I don't know if they tried or were not competent. I don't know that. All I know is that material was accepted at the site and left in that condition, where it needed to be finished responsibly into a finished compost material that can be utilized. Indeed, the legacy pile seems to be an anomaly, and it is certainly outside the norm of proper composting processes, at least according to GFL. In the county's respectful submission, this is a scenario that was not anticipated by the code, and the code's silence on the issue of storage of the legacy pile material awaiting recomposting for a period of more than 7 years does not mean that it would be allowed. To the contrary, if the registration or code were intended to allow the occupant to store waste feedstock on site for any lengthy time, it would have said so. This is not a storage facility. It's an active compost facility. Further, it is well established that the legacy pile is a source of odors. For instance, GFL's request for review specifically states at page 9 that GFL is aware that odors in the area have historically been a source of concern for the neighbors, and it is sensitive to the fact that it must deal carefully with the legacy pile in order to avoid unpleasant odors. GFL's request for review goes on to state at page 10, processing of the legacy pile has been processed at a rate that minimizes odors, which GFL understood was the preference of the community based on meetings with Wheatland administration as recently as May of 2019. As such, it is clear that GFL understands that the legacy pile is the source of odor. However, GFL wrongly suggests that its operation minimizes odors. The odors from the legacy piles are significant and noxious and have led to complaint after complaint about the public, and were determined by Brian Henderson on July 27, 2019 to constitute a nuisance warranting a remedial order. Council should reject any assertion by GFL that odors from the legacy pile are minimal. By using the words that GFL minimizes odors, it means that if it were to use legacy pile materials in compost at a greater rate than it does today, the odors would be worse, presumably much worse, than the odors that have been complained of in 2019. All of this suggests that the chief administration officer was reasonable to issue a remedial order requiring that GFL remove the legacy pile materials within 90 days. Without removing the legacy pile materials off-site without delay, the county and the public can simply expect to experience and suffer significant and noxious odors for years, or at least until GFL uses up the legacy materials at their current rate of processing. Furthermore, as detailed in the McCartney report at page 12, he conducted a site visit, albeit only to the perimeter of the facility, as GFL would not cooperate with his assessment, that took place on June 6th of 2018. Concerning the site visit, he stated, the strongest odors were detected downwind of the facility along the north property line. The odors detected were not typical of well-operated composting facilities, and at times they were quite offensive to all three participants. Notwithstanding this, GFL seems to want to evade responsibility in respect of odors. For instance, it has consistently pointed to other sources. As noted in GFL's request for review at page 9, it states, however, there are other sources of unpleasant odors nearby in Wheatland County, such as feedlots, other compost and waste facilities, and large agricultural cooperatives that fertilize their crops by spreading liquid manure. Under cross-examination by counsel for GFL in respect of an affidavit filed in related court proceeding, Brian Hendner stated at transcript page 43, line 9 through 19. However, I have to say that the odors produced from the GFL facility is entirely different from an agricultural facility. The odors from, like agricultural facilities, I smell every day. I grew up in rural Ontario, so so that's not unfamiliar to me. A scent that was very unfamiliar to me was going onto the GFL composting facility and smelling what was there. I've been on other landfills as a kid. I've been to the city landfills in Calgary. That was the worst smell I have ever smelled in my life, is at the GFL facility. The GFL facility is situated in a rural community among people like Brian Henderson who are very familiar with the smells associated with agricultural operations. It is very clear that the GFL site, and specifically legacy piles, are a source of odor. That is not consistent with typical agricultural activities. It should not be lost on this council that large portions of the community are not attending public hearings and forming organizations in protest of feedlots or the odors that are characteristic of them. In our respectful submission, the silence in the code of conduct on the storage of feedstock awaiting processing or reprocessing and the problems associated with the legacy product is precisely the type of legislative or regulatory gap in which it is appropriate for the county to regulate in a manner that is harmonious with the province. The approximately 7 years that the legacy pile has awaited processing is truly extraordinary, is unauthorized, and constitutes a nuisance. I'll now go on to the second prong of this aspect of our argument. So we would submit that GFL is also not authorized to store anything on site that is not composting material. Pursuant to the Environmental Protection and Enhancement Act, Activities Designation Regulation, at Section 2.1, which deals with definitions, a Class 1 compost facility is defined as a waste management facility where waste, not including hazardous waste, is decomposed through a controlled bio-oxidation process, including the thermophilic phase that results in stable humus-like material. By this definition, the legacy pile material are not part of any Class 1 compost facility. They are not subject to a controlled bio-oxidation process. To the contrary, they have been present for 7 years without any active or controlled bio-oxidation. The legacy pile materials do not themselves result in a stable humus-like material. The contrary, GFL has acknowledged in the cross-examination of Mr. Francis that they are not stable and must be blended with fresh organic waste to be processed at all. It is clear that by definition, a Class 1 compost facility is limited to waste that can be decomposed such that it results in a stable humus-like material. Further, the code specifically defines compost, not to belabor the point, as a stable humus-like material that results from the biological decomposition and stabilization of organic material under anaerobic and thermophilic conditions, is potentially beneficial to plant growth and is sanitized to a degree that protects human health. The code also defines feedstock to mean waste that contains organic materials which decompose biologically. When read together, these definitions make clear that the authorization that the facility is subject to is limited to organic materials that are compostable. In this regard, it is the county administration's submission that acceptance of material that do not readily decompose, such as inorganic substances like plastic, are not authorized pursuant to GFL's registration, nor is it authorized to store such materials in this case. In this case, the legacy pile materials on site. As detailed in the letter from counsel for GFL to council administration on January 2nd, 2018, included in tab F of GFL's review request, which is a response to the warning letter in connection with the litter from the facility. It is suggested that the litter issues at the site are related to the legacy compost. It states that the litter issues at the site are related to the legacy compost pile that contain plastic bags. In GFL's suggested solution to the problem in that same letter, it maintains that the problem will be resolved with the processing of the legacy pile. Yet 19 months have gone by since that letter, and the legacy pile still remains along with the plastic and debris associated with it. It is entirely within the county's purview to regulate this. As such, litter containing non-compostable organics like plastics is not authorized by the registration and clearly falls within the scope of the nuisance bylaw. GFL maintains that it does not store sulfur or dry oil on the site, and the county acknowledges that GFL has made some positive strides in this respect. However, under cross-examination on his affidavit on the issue of sulfur and dry oil, Mr. Francis at page 17, lines 9 through 11, states as follows. There's no stores of dry well mixed with compost on the site. There's some residue of dry well. Further, at page 17, lines 17 through 19, in respect of sulfur, Mr. Francis states, there's no stores of sulfur on site. There's some residue of sulfur still on the site. As such, while it is understood that GFL is not actively storing sulfur or dry well, the residue of it is present, and we don't know the extent of that residue. What is clear is that both dry well and sulfur are both present on site, and neither is part of GFL's composting activities, according to GFL. The dry well and sulfur on site are unauthorized, either because they are stored on site, which is an authorized storage of inorganic material. Neither of them is an organic waste that is capable of meeting the definition of a compost feedstock. And the AEP does not authorize storing inorganics like sulfur on site. And two, they are residue that is buried on, or they are residue that is buried on site, which is an unauthorized deposit of waste. The AEP registration does not authorize burying inorganics like sulfur on site. In fact, on the issue of dry well, Councillor for GFL admitted before the Court of Queen's Bench that, and he noted it again today, I believe, that some dry well was discovered after the orders were issued, which begs the question whether GFL really knows what is there, which in the county's submission only serves to warrant inspection and assessment action by independent consultants. The storage of sulfur and dry well, which in the form of residue or not, is not authorized by the registration, and there is a likewise basis for the county to regulate. Further, I would say that the registration of the facility does not permit the emission of any odor. GFL concedes that legacy piles have historically been the major source of foul odors arising from the facility, and that appropriate processing of the legacy has been a challenge since taking over the facility. It also appears to be accepted that the existence of the legacy pile is not in accordance with standard industry practice. There is nothing in the registration or relevant legislation that expressly permits a compost facility to emit any odor. Rather, the legislation and the code implicitly acknowledge that odors will arise from a compost facility, but mandate that operations at a compost facility must be conducted in a manner that minimizes those odors. The mere presence of the legacy pile is a contravention of this mandate, irrespective of how GFL is choosing to process them. GFL appears to take the position that it should not be held accountable for the nuisance created by the legacy piles because the legacy piles were generated by prior operators of the facility. This position should be rejected completely. The fact is, GFL's voluntarily acquired the facility, which included all of its assets and liabilities. The legacy piles are among those liabilities. GFL cannot absolve itself of this liability simply because it acquired the facility in June of 2017. If it didn't want to deal with the problems arising from the legacy piles, GFL should have insisted that the prior owner remove the legacy piles before the purchaser of the site. Alternatively, GFL could have negotiated a discounted price for this facility due to the presence of the legacy piles, and for all we know, they did. Or they could have negotiated an indemnity from the prior owners for any costs arising from the legacy piles. And for all we know, they did. What should not be accepted by council is that somehow GFL is absolved from any responsibility arising from the presence of the legacy piles simply because it didn't generate the legacy piles. GFL's position effectively strips a municipality of any recourse against any owner of a nuisance property that didn't create the nuisance. In such a case, a municipality would be powerless to enforce its own bylaws against any party that purchased but didn't generate the nuisance on the property that contravened a bylaw. This is clearly an absurd result, and therefore GFL's position on the issue ought to be rejected. GFL has also failed to meaningfully consult with the county when deciding how to proceed, how it will proceed with the legacy piles. Initially, GFL promised that it could process and remove the legacy piles in 3 months. Then it developed an action plan that projected that legacy piles would be completely processed within 10 months. Only a few months later, and with no input from the county, GFL advised that it would only be able to process half of the legacy pile by the end of April of 2018, but would complete the whole legacy pile by April of 2019. Here we are now in August of 2019, and a substantial portion of the legacy pile remains. Self-set deadlines have not been honored by GFL, and GFL has done little to engage the county in respect of this matter. Moreover, GFL has given conflicting reasons for delaying in the processing the legacy piles. In his affidavit, Mr. Francis states that there was a delay in processing the legacy piles due to the unexpectedly mild winter. That's at paragraph 44. But on cross-examination, he stated that processing of the legacy piles slows down in the winter months due to cold temperatures, which is at page 26. The legacy piles are the major source of the noxious odors arising from the facility. The mere existence of the legacy piles is a violation of the relevant legislation in respect of composting facilities in Alberta, and therefore the nuisance arising from the noxious odors created by the legacy piles is not authorized by any provincial registration. The odors observed at the facility at the time that the remedial orders were issued were foul and determined by the officer to create an unreasonable interference with the enjoyment or use of other property or the quality of life of county residents. As a result, the remedial orders in respect of the nuisance created by the legacy piles are valid orders issued by the county's administration. Next, I will discuss my point concerning how GFL has caused, allowed, or permitted the property to be an unsightly property contrary to Section 3.4 of the nuisance bylaw. Presence of the legacy piles are also a violation of Section 546 of the MGA and Section 3.4 of the nuisance bylaws in that it is unsightly property. Unsightly property is defined as any property that clearly shows signs of neglect or otherwise exhibits a significant lack of General Mason's cleanup or upkeep, and under the nuisance bylaw includes property having an excessive, unusual, or unreasonable accumulation of plastics, junk, or waste of any kind, as discussed earlier. The legacy piles are captured by these definitions. They exist because they have been neglected. If the material that constitutes the legacy piles had not been neglected, the legacy piles wouldn't be at the facility. Further, the legacy piles are composed of an accumulation of, among other things, plastic, waste, and various forms of organic material. This is clearly captured by the definition of unsightly property under the nuisance bylaw. Although GFL may not have generated the legacy piles, they permit the legacy piles to exist at the facility. Neither the NGA or the nuisance bylaw restrict the prohibition on unsightly property to those who generated the unsightly property. The legacy piles are not expressly permitted by the registration or any other applicable legislation. Rather, the registration and legislation is silent in respect of this issue. As a result, the county administration is permitted to issue orders pursuant to the MGA and the nuisance bylaws so long as those orders do not conflict with rights or obligations created under the provincial authority. No such conflict arises here. So next, I'll move on to just a discussion briefly of the contraventions of Section 3.5 of the nuisance bylaw. So you'll recall that GFL's argument that council should overturn the remedial orders because someone other than GFL was the first to create the legacy piles. Council rejects my earlier argument that it would be absurd, that would be an absurd interpretation of section 3.2 and 3.4 of the nuisance bylaw. We submit that GFL has in any event allowed or permitted the property to remain a nuisance, keyword being remain, or unsightly property contrary to section 3.5 of the nuisance bylaw. Simply put, GFL has allowed or permitted the legacy pile materials to remain without authority to be stored on site without processing them within a reasonable time, to the plastics, non-compostable organic waste to remain stored without authority in the legacy piles, as outlined in the transcripts from Mr. Francis. There's lime, an inorganic, compostable inorganic material that has remained stored without authority on site outside of the legacy pile. Drywall and sulfur, non-compostable inorganics that remain stored, or at least residue, which we don't know the extent of, remains stored on site without authority. And finally, the legacy piles materials remain emitting unauthorized, insignificant, and noxious odors. This is especially so whenever GFL disturbs the legacy pile materials for blending with fresh organic waste that GFL accepts onto the site. In these 5 ways, GFL has allowed or permitted a nuisance to remain on or to emanate from the site, contrary to section 3.5 of the nuisance bylaw. Further, GFL has allowed or permitted the property to remain an unsightly property. That is, GFL has allowed or permitted the property to remain showing signs of neglect or to otherwise exhibit significant lack of general maintenance, cleanup, upkeep, including to have remained on the property an excessive, unusual, and unreasonable accumulation of plastics and waste associated with the legacy piles. In these ways, GSL has allowed or permitted the property to remain an unsightly property, contrary to section 3.5 of the nuisance bylaw. You'll be pleased to know I'm almost done. So I just finally to deal with the final provision, which is section 146 of the MGA. Under the MGA, unsightly condition means I've gone through that. The remedial order recorded in the recitals that he formed the opinion that the property, because of its unsightly condition, is detrimental to the surrounding area. And it says, and whereas pursuant to section 541.011I of the Act, where in the opinion of the designated officer, because of its unsightly condition, is detrimental to the surrounding area, the designated officer may by written order require the owner of the property that it is in an unsightly condition to improve the appearance of the property in the manner specified. And then it goes on to say, and whereas such inspection and the information revealed the following conditions exist in and the property, which I unreasonably interfere with the use and enjoyment of other property or the quality of life of county residents, and 2, clearly show signs of neglect of which otherwise exhibit a significant lack of general maintenance, cleanup, or upkeep, and 3, pose or constitute an unreasonable risk, hazard or risk to the safety, health, or welfare of any persons or other property, and 4, show signs of serious disregard for general maintenance or upkeep. Namely, the relevant parts of the reasons for the order also record that the property conditions showing signs of serious disregard for general maintenance or upkeep, thus meeting the definition of an unsightly property, are noxious odors emanating from the property, storage of waste at the property, failure to properly dispose of feedstock requiring reprocessing, i.e. the legacy pile situated at the property in a timely manner. The record of the information before council reveals that GFL site is an unsightly property for the following reasons. Legacy pile remains on site. There's a serious disregard for general maintenance. The legacy pile has been there for 7 years, cannot be used in composting without significant blending with fresh organic waste. And the legacy pile emits what we will refer to as problem odors. The legacy pile contains plastics, non-compostable organic wastes. There is also a storage of lime on site, which discussed previously. If the lime And further, if the lime is not used in composting but is used in soil conditioning, the latter is not a permitted activity of the site as a Class 1 composting facility. Drywall and sulfur, again, we do know that there's residue of it. We don't know the extent of it. And then finally, under the MGA, detrimental to the surrounding area includes causing the decline of the market value of property in the surrounding area. And further, we say arises if the owner of or occupant causes noxious odors that significantly and adversely impact the use and enjoyment of property in their surrounding area. The property was detrimental to their surrounding area in our submission, likely for both of these reasons. Before issuing the remedial orders, Mr. Hend had reviewed the county file, including information from a realtor that previously told council in open chambers that she had difficulty selling parcels of lands in the surrounding area because of the conditions of the site and the noxious odors that came from the site. That we submit is an interference with the landowner property rights, including the rights to sell interest in land. We further submit that such decline in market value of property in the surrounding area meets the requirements authorizing the order under Section 546 of the Municipal Government Act. Further, Section 546 of the MGIT does not say that only a decline in market value can meet the definition of detrimental to surrounding areas. We submit this definition is also met where here an unsightly property interferes with the use and enjoyment of property in the surrounding area. Also, on the county file are complaints from residents in the surrounding area reporting that they are unable to use their land because of the noxious odors emanating from what is known as the legacy materials that shows signs of serious disregard and general maintenance for upkeep. In summary, whether council measures detrimental to surrounding area by measure of a decline in property value or hurdle to selling land in the surrounding area, or in the inability to use and enjoy land without unreasonable interference, such measures go against GFL and meets the requirements for an order under Section 546 of the MGA. And with that, I will conclude my submissions. Thank you.
Thank you. We're going to take a 10-minute recess. We'll reconvene at 3:40. Call the meeting back to order. To begin, I would like to invite any questions from council for Wheatland County Council's legal counsel. Seeing none, we'll start with presentations from the public. Out of respect for everybody's time, I'm just going to ask that everybody be as brief as possible. Try and minimize any redundancy. We will have you come to the podium and just identify yourself. We do record the videos. Good afternoon.
Is it on?
Yeah, and we don't have to be as close to these new microphones.
Will this show up?
We're just doing a new process so that during the video recording, what's on the screen, I believe, is going to be recorded as well.
So I'm talking about how GFL affects us. I'm Betty Lou Mercer, and we live right next to GFL. Okay, the GFL facility is located next to our property on the south boundary. This operation has been bane of our existence for the last 21 years. It's cost us countless hours of extra work, damaged our property, and wasted our time. It has negatively impacted our quality of life and threatened our health and that of our animals. We live with the worry that our water is being ruined and that at some time we could have our home burned down. I have even felt that at times I've been forced to supervise GFL. Now, granted, this is not all GFL. I would have to say that the last 7 years are the worst, but I'm going to talk to you as briefly as I can about the last 21 years of living there, and then you will get a better understanding of the full impact of it. So for 20 years, we have been supposed to phone a government number to report if we have an issue with the place. Well, we could all phone every day because nothing has ever been fixed, and it is always the same procedure. You're put on hold for a long time and made to stand around and waste your time until someone finally takes your call. Then the procedure of giving your information isn't quick either. And to what end? The calls have never done any good, so most of us have just given up calling because it's totally a lost cause. Then we're supposed to phone GFL if there's garbage in our field, and they will pick it up. Well, why can't they look and see if they've left their own garbage blowing around in our field? It shouldn't be too difficult to see there because there's always garbage there. Then we have to phone the fire department if there is a fire, because nobody is at the site to do it and we don't want our homes burnt down. Then, recently, we can't even drive any place behind the GFL trucks because they're afraid we are harassing them. Well, here is some history, and it is a sad story indeed for the residents of this area. In 1997, the operation was first registered as a small compost facility, and it was called International Compost Limited. It was allowed to accept 20,000 tons per year of feedstock. The land was leased from Gail Cleve, and International Compost worked in conjunction with Olds College, the Calgary Stampede, and perhaps an XL Food slaughterhouse as well. They accepted paunch material from slaughterhouses and composted it. They also took bedding material from the Stampede. There was no discussion with the residents of the area before the startup. International Compost just sprang up and began operations before anyone knew what was going on. Then we got the number to phone if there was a problem, which people did for years to no avail. Right away, the operation became known to the surrounding residents for the horrid smells. Over time, the smell got worse, and by 2011, it was so bad it defied description. The dreadful stink would seep into the house and settle in the basement where you could still smell it hours later. That was when the facility was trucking in liquid pig manure and other materials. Sometimes the liquid would get spilled on the roads. The smell was so bad we couldn't enjoy the yard in the nice weather because of the indescribable, awful, pervasive stench, which sometimes reached as far as Rosebud or Strathmore. This summer it has smelled a lot as the facility continues to operate in spite of the stop work order from the county council. Our concerns escalated rapidly as time went by. Coyotes were attracted to the animal parts and rotten food and garbage that were brought to the site, and soon became a big problem. The coyotes were not afraid of people. When I went for a walk in our field, a coyote might stand and look at me and I couldn't scare it off. So I carried a .22 when I walked in our field to protect myself and the dogs. A Hutterite friend caught 50 coyotes one winter in the area near the compost facility. A woman driving to work stopped one morning and shot 4 coyotes by the gate into our field. The coyotes began to come in our yard at night and attack the dogs and cats. Our Jack Russell had surgery for major injuries he sustained in our yard when he went outside for one last run before bedtime. One coyote had a den at the edge of the lawn and the trees. They even chewed the garden hoses, so they were unusable. We went from over 20 barn cats down to 6. Our beautiful house cat, Angus, disappeared one night as well when I couldn't get him to come in. The next morning, never saw him again. All from this big influx of coyotes that came from this facility that is GFL. I'll give you another picture here. The quantity of flies in our home increased because they reproduced in the piles at GFL until 3 years ago they became unbearable. They were everywhere. They crawled on the buildings, entered the house, bothered the animals, and dive-bombed our faces and eyes and tried to get in your mouth. They messed on our doors and buildings and created a lot of extra work. There were fly bodies on all the window sills of the outbuildings and messes on the house window frames. There are somewhat fewer flies now, but this summer they have been a real pain in the shop. It's a closed shop, but you have to open the big door to get vehicles in and out. Then the flies come in. Our son spends a lot of time working on our vehicles in the shop, and when he is on the floor under a vehicle, the flies get on his face and arms and legs and try to crawl up the legs of his shorts. It is just gross. Sometimes I go out there and swat flies so they don't bother him so much. If we're sitting in the shop having drinks, because we can't sit outside because of the flies and the stink, someone always has the fly swatter in their hand to kill the flies when they come to bother us. There have always been seagulls at the composting facility, but by 2012 they'd really increased. It looked like there were thousands of seagulls which were drawn to the garbage at the site. Seagulls predate the crops and bring disease. It's been proven that seagulls are responsible for E. coli contamination, and they're carriers of antibiotic-resistant bacteria. We have them all year round. Early this summer, we had flocks of them wheeling overhead around and around when we worked outside. I don't know what they were doing. They just flew around and around in circles, making a noise. They broke the eggs in a Canada goose nest on a sea can that we have. Those geese re-nested and did manage to get a little clutch of goslings hatched, but they were way later than the other geese. There is a large lake just north of our place and many smaller wetlands in the area. For years, we could hear frogs on spring and summer evenings. By 2011, we seldom heard frogs anymore. Frogs are an indicator species. That means their presence or absence in the environment indicates the strength of the ecology there. No frogs anymore around us, so that means the ecology is not healthy. About 2013, massive piles of drywall were collected at what was then called BioCycle. There was plastic pipes, wires, buckets, food containers, and other garbage. Plastic and paper blew from the piles of drywall into the fields, into the ditches, and got caught in the fences. there is trash stuck in our Caragana hedges, in the bottom of the cattle guards, on the ground along the fence lines, and sunk in the lake water. It even showed up on the lawn. The other day there was fresh garbage in our field where John had oats planted. The garbage is caught in the swaths. It blew directly off from GFL. On May 30th, 2016, registration for the bicycle site was transferred to BioCan Limited. The piles of broken up drywall grew, as did the trash blowing into the fields. People complained increasingly about the smell of the flies. We all were concerned that our property values were decreasing, and realtors said that buyers were not interested in purchasing in the area affected by the compost facility. Oh, great. The investment we have made in our homes has gone down the tube. By this time, the piles of broken up drywall were estimated to be over 40 feet high and contained approximately 43,000 tons of material. These were a blight on the landscape. The giant piles have since been ground up into smaller piles, but that process caused even worse problems as the dust was blown onto our field and the crop there. When the drywall dust gets wet, it later it later dried to a hard 1/4 inch crust on the land. When the soil was tested on our cropland, 1 out of 9 samples was shown to contain asbestos. Alberta Environment downplayed the impact of this finding, but that works out to 11% of the land where the drywall dust fell had asbestos. That equals 7.7 acres of our land with asbestos. And that land is being used to raise crops or animals, which eventually feed people. 2017 also brought with it the danger of sulfur at the GFL facility. There were 2,000 tons at the GFL site. Is that right? 2,000? 20,000? 20,000 tons at the GFL site. 10 times the allowable quantity, and it wasn't properly stored. Inhalation of sulfur fumes causes irritation of the eyes, nose, and respiratory tract, headaches, dizziness, and nausea. High levels of sulfur cause more severe problems. Sulfur dust suspended in the air is readily ignited by fumes or static electricity. We were all fearful of fire, starting at the plant and the silent threat of the poisonous gas H2S being given off. This gas moves low to the ground and can kill people and animals that inhale it. In June of 2017, just such a fire got started at GFL. One of the residents of the area called the fire department. That fire was a screener or some type of conveyor machine burning up. Apparently, cooling machines can start a slow burn. That can be out of control hours after the men have stopped working. So I will show you how the smoke moved, I think. There's a low layer of smoke. John's cows were out in that field, and it was toxic to the cows. No, that's drywall being ground up. Here's the, no, that's the smoke. And his cows moved ahead of the smoke and they all jammed themselves in the corner of a field up there, trying to get away from it. Here's another picture of the smoke. The smoke moved low and to the northeast. One of the residents of the area called the fire department, and then we alerted each other. We had no warning from GFL about that. Then in September 2017, a large fire broke out at the facility. That time, several residents called the fire department because the huge plume of black smoke could be seen at Nightingale and further. No workers were at the GFL plant at the time, and the firemen had to force their way in the locked gate. That fire was a screener or a conveyor machine burning up. Apparently, oh, I read that already. Okay, the huge windstorms, here we go. The huge windstorms and hot, dry weather that we had that summer of 2017 could have spread a fire so fast that we were concerned that we could lose our home before the fire department had time to get there. So our family bought firefighting equipment at a cost of over $4,000 to protect our home and buildings in case of fire. It sits in the yard full of water and ready in case of emergency. It will spray water for 8 minutes, and then we'd have to take it to the lake to get refilled. Another expense and work for us, caused by GFL. Trucks going to and from the GFL facility are turning the gravel roads to dust. We get our vehicles coated with dust inside and out when we travel. The roads are all washboarded in spite of the efforts of the grader operators. If you drive a good vehicle on these roads, it is no time before it is full of rattles and noises. And the clothes hanging in the closets at our home get road dust on them. Thank you for that, GFL. In 2017, some of the residents most affected by the GFL facility formed a nonprofit organization called Neighbors Against Pollution, or NAP. We have worked hard to try to resolve some of the issues, but it is taking a long time and we all have busy lives and better things to do. We don't get together in a big group just for the fun of it or for social interaction or to come and bother the council. In this struggle, we're valiantly attempting to maintain our quality of life and the environment. I could list some of the things our NAP group has done, but it would take too long. And this is my prologue. 2019, August 16th, 3:02. As I finished writing this essay, the phone rang. It was a NAP member calling to say that there was another fire at GFL and their machine had dug down an estimated 15 feet trying to put the fire out. I guess that would ensure that the clay liner that's supposed to be under the facility is no longer secure, if it ever was. So I wondered then if I should go to town and start buying drinking water because the water table might have finally been irrevocably polluted. But I don't want to. We had a new well drilled in 2012 that cost $15,000, including the pumps and tanks and everything, the one pump and 2 tanks, and everything that went with it. The wells on our property have produced good water for 100 years, more than 100 years. Why can't we still have a reliable supply of drinking water? Because some big company has chosen to move in next door and disobey the laws and regulations, all for their own monetary gain. This is not fair to the rest of us who are trying to go about our business and live our lives in a decent and responsible way. And if GFL is concerned about lost revenue, I have no sympathy for that company because they've been taking advantage of the people in this area for a lot longer than they should have been. They ruin our lives and destroy the environment. The owners of GFL and the workers at GFL should earn a living in an honest way like the rest of us do. And I have a lot more that I could say about the problem, but sorry, I'm done for now. Thanks for listening.
Thank you.
My name is John Calvin. Betty Lou has kind of covered everything that we've already covered many times over, but I would just like to maybe add a few things. We actually have been leasing the property right next to GFL and have had a lot of problems between birds that have cleaned some of our crop off. Several years ago, we've had a real influx of ravens come in that actually picked a couple eyes out of our calves that we had to put down. It's just been a problem. We live straight north of it, just a couple 100 meters north of the Mercer residence on the other side of the lake that you saw. And we have to look at that facility. We don't get to look at rolling hills or any other people would think maybe it was a mountain in the background, but it's a big garbage dump. This is a picture of seagulls that we had seeded some rye for fall grazing, and I didn't realize seagulls were grazers, but when that rye comes up when it's little, we had to replant it. They did help me out with that, but it's just a continuous headache. I believe it was the first year that they took over. They also, there's a picture of our cows with the sulfur smoke coming through the low valley. But anyways, it's just been an ongoing, and we've been living it. Also, this is all our property, which basically joins up to the northeast of the facility, and we've got another section of grass and hayland directly to the west. Areas where that we'd have the possibility to put acreages, but there's no way that we're even going to bother trying with a facility like this in the area. This is a picture where they actually pushed gyprock, and supposedly that gyprock is supposed to be new gyprock. Well, I can tell you, I know what a little bit of gyprock is around. That was all garbage gyprock that came from probably out of BC that had. And we took the samples to get our asbestos out of that little sampling that came across the fence. It's just been a total nightmare. We started as a small group. Trying to get some resolution to this problem, and it was a very slow process. We were heard but ignored, heard and ignored until we finally got enough people together to make an impact. And I sure hope the council here does their diligence and make sure that something is resolved. Thank you.
I'm going to be reading an email from Joanne Melville, who couldn't be here today. This is a picture of her son. It says, to whom it may concern, I'm writing in regards to the GFL facility north of Strathmore. I live a few miles away from the facility and have 2 little boys that have medical issues that could be from GFL. We believe this is because of the events after pile disruption. My 5-year-old has enlarged thyroids that the doctors have no idea why it's been acting up since he was 2. We have been to cancer specialists. They have done months of blood work to see if they can figure out what is causing it, and no answers. My 4-year-old has respiratory problems that the environment specialist says it could be caused from the sulfur, but they would not know until more testing is done. Again, it's been a few years. He has been hospitalized twice now for breathing problems, taken to the Children's by ambulance for a week's stay. Some nights his oxygen levels drop to 86 when he's sleeping, and after waking him up to take him to the hospital, his levels go back up to the 90s. They thought it was asthma 2 years ago, but he was cleared after time and testing being done. The last time he was admitted to the hospital, they gave him Ventolin. His levels dropped to 75. We spent 4 days in the hospital. This is no way for 2 little kids to live. They love to play outside. Not only does this disrupt their lives, but it also takes away from work and for a number of days while in hospital. Once we have further results from testing on what is in the piles at GFL, they can make a more educated guess at what might be causing the problem and a direction of what testing can be done. In the future, the boys have testing to do once they are a little older. Some tests we know of are oxygen monitoring at night, lung capacity testing. Long story short, in my opinion, the doctors can't diagnose a problem as they don't know what they are looking for. So hopefully when we have more tests done on what is in the facility, the doctors will know exactly what to test for. Sincerely, Joanne Melville.
Can you just identify yourself for the...
Oh, my name's Jamie Huckstead.
Hi, I'm Colin Huckstead. I'd like to introduce you to my wife, Mrs. Huckstead back there. My name was brought up earlier today, so I just wanted you to meet her. And I have one question for Bonnie. Did you and I ever meet with Brian Henderson? You never did? June 27th, 2019? Just so that's on the record. Everything I'm going to say today is, in my opinion, without prejudice, because I've gone through a little bit of hell with this outfit. So I'm just going to start out with it. I'm not going to go through a whole bunch of stuff. Everybody's covered it. But there is some stuff here that we got to get clear. There was a fire last week. It was a little fire, but it took 2 days to put out. I don't class that as a little fire, but another reason why a lot of us quit phoning in and complaining, it was falling on deaf ears. We had comebacks that we were told it's been a feedlot. The wind's blowing the wrong direction. It wasn't going to you. But just for the record, I've been in the waste industry for 35 years. I'm a professional composter. I know the difference between compost and manure. I worked at the feedlots when I was younger, but I just thought that should be out there. Now, there's been a lot of talk about all the, I'm a little nervous. Been a lot of talk about the drywall. So Knapp did several FOIPs to lots of places. And this just happened. This is brand new stuff. You're going to hear it for the first time. I'm going to pass this stuff around. I have no idea what it means, but I think it should be looked at and investigated or questioned. To everybody up front. All these people.
We'll provide you a copy.
Sure. You want to look at mine? Sir?
Yes, Mr. Thompson can review it prior to it going to
Yep. Give him.
Robertson, I'm sorry.
So what it is, while you're reading it, it's the first page. It goes,
Oh, I get a copy as well. That'd be great. Thanks.
it comes from OH&S, and it's on this GFL site. And the first one is an email where she says, I have left you a voicemail so that you can arrange a meeting for us to discuss the protection of your workers for potential asbestos exposed. On 2 examples contained more than 1% asbestos in drywall and cannot be considered homogeneous as far as asbestos goes.
Can our legal counsel have a copy as
Now you can pass it around. I don't know why you're wanting to read it before they do, but I know.
We're just taking a look for admissibility.
Okay.
Yeah.
Do you want me to slow down? Okay, you read it
Yeah,
before I
maybe you
read.
could just give him just a minute to quickly
Sure.
review it.
I've never been accused as a speed reader. That's two of us.
legal counsel can just advise after they've reviewed it.
Okay, so we're done the first page, I hope. So then the
We'll
next
just
one.
give them a moment, Mr. Hugston.
Okay. Oh, okay, sorry. So anyway, this is the drywall piles out there while we're reading. Maybe we can go to some of those other pictures. The one that I was really surprised was the one that Johnny Kelpin showed where that stuff was traveling in the wind. The one picture where the Texas gate, that's heading right towards my house. We live about a mile as a crow flies. This is my own knowledge. There was over 40,000 ton of drywall out there at one time. It was coming from BC. That's how we were able to track this down. But meanwhile, all that stuff was drifting into our areas. Where's it stop? Who knows? You asking? Okay. I'll hold my horses. This came from OH&S. We FOIP'd them, and I have no idea what any of this stuff means, but I just think there's enough importance that everybody here should have a look at it and maybe make their own, or maybe get a professional to, but I know OH&S reacted to it, so I can start now?
I'm going to object to the review of this material simply because it's part of a FOIP request that apparently Mr. Huckstead made. We don't know what other documents were contained in the FOIP request or provided. He's indicated that he doesn't know what it is, but he thinks it's important, and so he wants to read it.
It has a lot to do with our health out here. This is what was been the most fearful for us. If you remember way back, Knapp wrote a letter and requested council, GFL, Alberta Environment, let us bring a third party in and test that drywall because we were so nervous about it. And it was refused. It was told that we were making stuff up, that the drywall was all from the new housing. It says in here, it's not from new.
Mr. Hugside, could I just want to, in terms of, you know, I think that from our perspective, you know, when a landowner wants to put some information before council in the context of an administrative proceeding like this, we don't really have any objection to this, although we would caution council on the appropriate weight that they might apply to it. So from our perspective, I don't particularly see a major issue with it being entered, but ultimately, you know, would expect that you could deal with any concerns in respect of weight.
Given that our hearing today has quite a narrow focus and that council is reviewing the remedial orders that were issued by administration, we're not going to consider this documentation for that review. It wasn't a part of the information that both the administration has considered or GFL's council has considered with their application for appeal. So council will not be integrating this into our review for this. But if there's further consideration of new information that needs to be done by either our administration or in conjunction with GFL. That can happen at a future date. We need to keep the proceedings today focused on the remedial orders that were issued and a review of those orders and the facts that they were issued based on.
I completely understand that. I just found this last night, like it was, and I couldn't leave it
And I'm
without.
not saying that it's not important information.
Correct.
It just needs to come at an appropriate time and place.
Perfect. And I guess that's all I have to say. Except for a few pictures. There's some drywall blowing, some drywall dust blowing with what, we don't know what's in it. And it's going my way. So I guess that's why I brought it up. Thank you.
Thank you. Are there other members of the public who would like to speak to the review? Not seeing any further requests from the public to speak, I'll ask Mr. Robertson for some closing remarks or to respond to anything that's been brought up this afternoon.
Thank you. So, I think I'll respond first to the suggestion that the appeal is out of time. And as my friend observed, it's been, it was more than 14 days and, sorry, more than 7 days and less than 14 days. And if you turn to the, to tabs 18 and 20 of, oh, beg your pardon, I'm referring to different documents, but I'd like to refer to just the remedial orders themselves, the July 3 and July 5, 2019 remedial orders. If you turn to the second last page of each of them, you'll see that GFL was told by the Chief Administrative Officer for Wheatland County that you may request that Wheatland County Council review this remedial order in accordance with Section 547 and Section 6 of the bylaw by providing written notice of your review request, including grounds for the review request, to Wheatland County within 14 days of receipt of this remedial order at the following address. The same 14-day period appears on the order of July 5th in the same place. So we just merely took the Chief Administrative Officer at his word on the appeal periods. I don't think that it should lie in the mouth of the Chief Administrative Officer's Council now to say you shouldn't have trusted us and we're not relied on that statement. So if there is an argument that there's a shorter appeal period that applies, I'd suggest that it's been waived by the Chief Administrative Officer with respect to that, with respect to the appeal by providing a longer period in the notices themselves. With respect to the storage of, alleged storage of plastic, and my friend's rather, I'd suggest, remarkable position that because there is nothing in the legislation he could find that permits it, it must not be allowable under the registration. You can see from the questions that were asked of council, and I'm referring to our tab D. This is asked to AEP, and there's a couple of instances where it's clear that Mr. Jorgensen is well aware that there is plastic in the pile, and AEP is responsible for administering the registration, and AEP does not appear to be concerned by the fact that it's there. In fact, he says, with respect to after answering that, or requesting samples of the piles, he describes drywall, sulfur, and tailing, And he says the tailing pile is standard composting material, organics that do not fully decompose in the first trip through the composting process, and foreign matter such as plastics. So it's not something that is that AEP is unaware of. It is something that is that comes out of the compost in the process. In the process of making compost, obviously.
I'll ask that members of the public maintain respect.
So with respect to suggestion, my friend I'll make a general observation that Mr. McGilvery has not, for the most part, fairly stated our arguments in responding to them. He has blown them up to go well beyond what we have been suggesting by them. But talks about how the letters from GFL's counsel in conversation with, or discussion with either counsel for the county or the administrator, Mr. Parker, I think it was at the time, and if you look at them, you see that GFL may say, we disagree this constitutes a nuisance, but we'll build a fence. We disagree that constitutes a nuisance, but we'll put up catchers to prevent that from happening. And so they're taking the position that it's not a nuisance, but they're doing things. And I couldn't help but be struck by what Ms. Mercer said when she said we complain and complain and nothing happens. But actually a lot has happened since GFL took over the facility. And my friend has, on a number of occasions, he refers to periods going back 7 years. And I would remind the council that GFL has only been the owner of this facility since June of 2019. And, sorry, 2017. 2017. Sorry, I misspoke. But 2017. So it's been less than 2 years. But my friend and others, and the general theme in the statements that were made by the public members, and I can see the pictures, and I understand their concerns, but the fact is that most of the pictures, in fact all of the pictures as far as I could see, are not the facility as it now exists, or existed at the time that the order was granted, at the time that there was said to be a nuisance. There is no 40-foot tall pile of drywall. There is no mountain of sulfur. That's not what is on the site today. There's no question about that. Mr. Henderson admitted that he did not see, when he inspected the site, he didn't see the stores of sulfur. He didn't see the stores of gypsum. They're not there anymore because GFL removed them. There's a suggestion, I mean, my friend has suggested that fires are a common occurrence, and frankly, there are 3 that are referenced today over the course of the last 2 years. And the suggestion that the fire yesterday, or the last, I think the 16th, took place and had anything in common with any of the others, I think is quite a stretch. As I understand, the September of 2017 fire, that was a machine that was running on site when nobody from GFL was working, and it was running empty. And as happens when machines run empty, it got too hot and a fire started. There was nobody from GFL there to run the machine. So that was the concern, I think, and that's why there was a suggestion that it was being investigated as a matter of arson. There's no suggestion as to who might have done it, but it's not. If it's a matter of arson, it's not the fault of GFL. And there's a difference between the commission not being able to conclude whether or not it was arson and opening the investigation as such. So it is possibly arson. And if the investigation is concluded without more, then it remains that. But that's important for today only because that is one of the reasons that Mr. Francis gave as that particular incident was one of the things that delayed the more immediate processing of the legacy pile. There were a number of instances over the first several months that caused that difficulty, and he talks about that in his affidavit. It's in there to read. Now, reference again to the suggestion that the compost code of practice is silent on storage, and that therefore must mean that no amount of storage is, or anything more than I think my friend was suggesting more than a few days of storage of compost would be acceptable. This property is zoned agricultural, and one of the discretionary uses of agriculturally zoned property is a compost facility. And a compost facility in the land use bylaw enforced at the time that this facility was opened defines a compost facility as makes a couple of references to what a compost facility does, but it also says, and one of the uses is storing unprocessed compost. It doesn't say how much. No one is suggesting that GFL would want to have the legacy pile. No one would want to have the legacy pile. It's also, I would suggest, rather inaccurate to say that it is a nuisance that GFL has either permitted or allowed or
Allowed to remain.
Pardon me?
Remain.
Or allowed to remain. Because if you consider, especially what GFL has done with it over the period of time that's relevant, which is the period of time leading up to the order, they're in the process of actually processing and removing the pile. The one thing they're not doing is permitting it to remain. They're processing it as fast as they believe is reasonable and is unlikely to cause a greater problem for their neighbors. So they're not doing any of the things that would normally be ascribed to a nuisance. The one thing they're not doing is trying to leave it there. They're trying to process it and get it off. My friend had suggested that the additional period suggested by GFL could be as much as 3 years, and I have never been able to see where it says that. My understanding is that the suggestion was 18 months, and that's accounting for weather. So it's not 3 years that was being suggested. say that, I mean, my friend has, again, on a number of occasions, has, I'd suggest, stretched to the limits some of the definitions by trying to argue that the legacy piles are neglected by GFL. I mean, they're not. They are being processed. There is a disagreement about the speed with which they can be processed, but they are being processed. So they're not being neglected. And what else can you do with a pile of unprocessed compost except process it as quickly as you can? Raises an interesting question, because of course all of that land, all of that compost that's in the legacy pile was taken there so that it wouldn't end up in a landfill, and that's what GFL is trying to do with it. It's trying to avoid it going to a landfill. It's trying to process it, turn it into compost. Now, there is no indication from Alberta Environment, and I have heard no suggestion today, that I haven't heard anyone say that they have had their wells tested and have found contaminants in them. And there has been, as you know, a groundwater study that was completed. The report was provided relatively recently. The report was provided in February, was provided to Mr. Henderson, and also to, obviously, Alberta Environment. And no concerns have been raised with respect to that groundwater study, which means that the clay pad is intact. Water contaminants of any kind are not leaking into the groundwater. And so I understand that, and I've heard people say they're very concerned about a number of things. And I completely accept that they are absolutely sincere in their concern. But the concern about groundwater, for example, is not one that is borne out or backed up by any actual evidence. It's a fear. And I completely accept it's a real fear, but it is not, and it's caused by their reaction to proximity to the GFL site, but there's no indication that there is any damage to the groundwater. Also, no indication that simple combustion of sulfur results in H2S gas. I doubt that conclusion, and I would invite the council to investigate it. Simple combustion of an open pile. But in any event, there is no more drywall. There is no more sulfur. There's I think Mr. Francis described it as remnants. There are occasionally they'll dig down and find a little bit of sulfur, which is not perhaps surprising considering that there was a 20,000 ton mountain of sulfur at one point. But the sulfur and the drywall are, and almost all the conditions that were presented in the pictures shared by the public members refer to conditions that simply do not exist anymore. And didn't exist, more importantly, didn't exist when these orders were made.
I just have one question.
Of course.
You state that this product has been removed. Do you have any documents to support that? Do you have any documents to support that? Transportation documents that you've hauled the sulfur off-site, the drywall off-site, loads, weights, things like that? Do you have documents to support that that's been done?
Have not presented any here, but I mean, you can see from the aerial photographs that there's no sulfur. There's 20,000 tons of sulfur. You saw the mountain of sulfur in the pictures.
Pardon me. Being that it's transportation of dangerous goods, there must be documents that are presented when it's moved.
There are.
So that would be an easy way to answer a question. Just saying.
Well, I can make that inquiry. But I can make that inquiry, but we have the same, I think we may have a difficulty about whether or not they can be. I can make that inquiry, but I have to consider, I'll need to consider whether they can be produced in the circumstances, but I will certainly look into that.
Mr. Robertson has advised that he'll make the inquiry. He's not certain that it's pertinent to the considerations today, as they weren't a consideration for the remedial orders, but it may be something to be looked at in the future. Did you have further closing remarks?
Well, I believe that brings me to the conclusion of my comments.
Does council have any further questions?
Madam Reeve, I just wondered if I could have 2 minutes to confer with my client to determine if there's anything arising. Thank you.
Well, perhaps council will move in camera just for a brief legal consultation. I'll move in camera. All in favor? Motion is carried. Council out of camera. All in favor? Motion is carried. Mr. McGilvery, did you have any final comments?
No, we're good. Thank you.
Thank you. Mr. Robertson, anything final? Council is going to, I'm going to move us back in camera for further deliberation. We just wanted to ensure if there was any further comments that we were considering everything in our deliberations. I'll move us in camera. All in favor? Opposed? Motion is carried. I apologize for the delay. Council just needs to ensure that we're doing our due diligence and considering all of the information that's been presented to us. We'll be all in favor? Motion is carried. First of all, I want to thank everybody for your patience today. I know it's been a long afternoon. I'd like to thank Mr. Robertson, Mr. McGilvery, and the public for your submissions and your presentations today. Council has a significant amount of material and would like to deliberate on everything, including the submissions that we heard today. We anticipate having a decision in approximately 2 weeks. If possible, we will issue a decision prior to that. Council would request that Mr. Robertson respond to the request for information regarding the transportation of materials. Do you think Friday by noon would give you appropriate time to collect that information? To provide a response, thank you. This adjourns today's review hearing. Out of the interest of fairness, I do ask that council will not be discussing this review hearing while we're in our deliberations. And that adjourns this review. Thank you. Council, we do have 3 matters left on the agenda. He didn't come, so maybe we'll table that. Because I think Mike said that he hoped for him to be here to speak to it. I'll check with Brian, I'm not sure. Thank you.
Yes, so maybe I'll follow up.
Yeah, I think your email was on one of the pieces. Actually, you know what, I'll give you a card and then maybe you could shoot me an email directly. That's okay, it's not private. I'll make a motion that council move in camera for the remaining agenda items. Or, is that okay? All in favor? Motion is carried. Motion considering fire board membership.
I'd like to make a motion that council remove fire board member due to ineligibility as per bylaw 2019-01, section 3.6. Further, that administration advertise for a citizen-at-large position for the Wheatland County Fire Board.
Any questions or discussion? Yes. Brian will have the wording. It was in an RFD that was circulated. Any questions or discussion? All in favor? Motion is carried. A motion regarding regional broadband. Annual cost up to $30,000. Questions or discussion? All in favor? Motion is carried. In September in Edmonton. Any questions or discussion? All in favor? Motion is carried. I believe I will, yes. It's in Edmonton, so it will be in Calgary the following year, but this year's Edmonton. Right. Motion to adjourn. Councillor Clausen, all in favor? Motion is carried.